I am calling to order this meeting. This is an additional meeting of the Committee of the Whole of the Council of the District of Columbia. I am Phil Mendelson, Chair of the Council and Chair of the Committee of the Whole. Today is Tuesday, February 6, 2024. The time is 12:56 in the afternoon. And this meeting is being held in the Council Chambers, Room 500 of the Johnny Wilson Building. This is an additional meeting. That is, it's not a regularly scheduled meeting of the Committee of the Whole. This meeting will be followed by a regular monthly legislative meeting. There are at least a couple of members who are participating virtually, but the other members are here present on the dais. We always begin our Committee of the Whole meetings determining whether we have a quorum. Mr. Cash, would you call the roll?
Chairman Mendelson.
Present.
Councilmember Allen. Here. Councilmember Bonds.
Here.
Councilmember Fruitman.
Present.
Councilmember Gray.
Here.
Councilmember Henderson.
Here.
Councilmember Lewis George.
Here.
Councilmember McDuffie.
Here.
Councilmember Nadeau. Councilmember Nadeau. Councilmember Parker.
Here.
Councilmember Pinto.
Present.
Councilmember Robert White.
Present.
Councilmember Trey Onway.
Present.
Mr. Chairman, you have the quorum.
Thank you, Mr. Cash. We have one item for markup in the Committee of the Whole, and then we have, I believe it's 5 measures that are being reported out of the Judiciary Committee for what we call agendizing to the legislative meeting. The item for markup in the Committee of the Whole is PR 25-507, entitled the District of Columbia Sentencing Commission Joel Caston Appointment Resolution of 2024. Purpose of this resolution is to appoint Mr. Caston as a member of the District of Columbia Sentencing Commission for a 3-year term to end July 2nd, 2026. He would be filling the seat replacing Molly Gill. Mr. Caston is a Ward 7 resident. He is a formerly incarcerated native Washingtonian who has been directly impacted by the district's criminal justice system. He is a licensed health and life insurance agent and also serves as a mentor, writer, and activist. Mr. Caston was a founding member of the Young Men Emerging Mentor Program with the District of Columbia Department of Corrections, participating from 2018 to 2023. Most notably in 2021, Mr. Caston was elected Advisory Neighborhood Commissioner of ANC 7F, becoming the first incarcerated person elected to public office in the history of the district government. The single-member district included the DC Jail, the Harriet Tubman Women's Shelter, and a luxury apartment complex. Mr. Caston held office for 2 years, completing his term in 2023. While in office, he served as treasurer of the ANC and as co-chair of the Ward 7 Redistricting Task Force. The origin of the Sentencing Commission was the creation of a pilot program by the council in 1998, tasking the then-named Advisory Commission on Sentencing with the development of sentencing guidelines. The resulting product, a set of voluntary sentencing guidelines, was then monitored by the commission, which collected, reviewed, and analyzed data from judges and criminal justice practitioners. The purpose of the guidelines is to promote consistency in sentencing, to avoid wide disparities in sentences when the crime and criminal history are very similar. The role of the Sentencing Commission is to revise and implement a system of voluntary sentence guidelines for use in the District of Columbia Superior Court designed to achieve the goals of consistency and adequacy of punishment with due regard for, first, the seriousness of the offense, second, the dangerousness of the offender, third, the need to protect the safety of the community, fourth, the offender's potential for rehabilitation, and fifth, the use of alternatives to prison. In addition, on an annual basis, the Sentencing Commission is required to file a report with the council that contains an analysis of the sentences imposed and describes how it ranked a new felony offense or re-ranked any existing felony offense and the resulting guideline sentencing options. The Sentencing Commission does not decide sentences. Maximums and minimums are prescribed in the statute. And as for the guidelines, judges are free to depart from the guidelines and sometimes do. Currently, the Sentencing Commission has 12 voting members plus 5 non-voting members. I'll note that the Secure DC legislation will make some changes, increasing the size of the commission. But at the moment, there are 12 voting plus 5 non-voting members. Virtually all of the work is done by consensus. I believe we were told recently there was 1 vote in the last 5 years that was not by consensus. Voting membership includes 3 judges, 2 prosecutors, 2 former prosecutors, and the CSOSA director. The non-voting members currently are Metropolitan Police Department, the Department of Corrections, the Federal Bureau of Prisons, the U.S. Parole Commission, and the council chair, our council chair of the Judiciary and Public Safety Committee. Because of his personal experience with the criminal justice system, demonstrated interest in and advocacy related to criminal justice policy, and because of the commission's expressed desire to include the voice and perspective of a returning citizen on the commission, I'm recommending, and if the council approves this, or the committee approves this, the committee would be recommending the appointment of Mr. Caston to the District of Columbia Sentencing Commission for a term to expire, what did I say, on July 2nd, 2026. I move the print with leave for staff to make technical and conforming changes. Is there discussion? I'm going to take Councilmember Pinto and then Councilmember Trayon White.
Thank you very much, Mr. Chairman. As I articulated last time we debated this issue, I think that the perspective of returning citizen can be really valuable on the Sentencing Commission. I included a provision in my Secure DC legislation requiring one of the council's nominees to be a person with lived experience as a returning citizen. We're also increasing representation to give the council one additional appointee, as well as to give the mayor one additional appointee, and to require that two of the appointees of the courts, one would have to have prosecutorial experience, one would have to have defense experience, as well make MPD a voting member. I continue to believe that the commission needs this additional representation from a wide array of perspectives, from people with lived experience as returning citizens, from police, from prosecutors, and from defense attorneys. And that's why Secure DC increases that representation. These perspectives are also very important as our Sentencing Commission really does play a crucial role in guiding the courts with the sentencing of crimes committed in our communities. As we know, over 98% of sentences are aligned with Sentencing Commission guidelines. So I am supporting this nomination today. I believe a diversity of perspectives is very important, and appreciate you working together on this, and Mr. Caston's commitment to the city.
Thank you, Councilmember. Councilmember Trayon White.
Yes, thank you, Chairman. I had the opportunity of meeting Mr. Caston while he was incarcerated at DC jail at our Fathers Matters program years ago. I want to say that he is a very intelligent man with a renewed perspective. There was some pushback about his nomination, but I want to say that he's paid his debt to society. In fact, he's probably created a number of relationships, learned experiences, that give him the information on how to give guidance to this commission. I think he also has a unique perspective. Mr. Caston served 27 years being incarcerated, and I believe that in speaking with him, he would give fair and just recommendations and a unique perspective to the Sentencing Commission. And so today, I'm proud of him. He was not only advisory neighborhood for 7F07, but also a strong advocate and community support worker while returning to the community. So I look forward to supporting Mr. Caston nomination to the Citizens Commission today. Thank you.
Thank you, Councilmember. Is there any further discussion? Councilmember Bonds?
Thank you very much, Chairman. I just want to reiterate my position from the last opportunity to speak on this nomination and to say that, you know, I feel it's certainly the right direction for us to move in. We say as a society that giving individuals a second chance is tantamount to being and having the American experience. Well, here we go. We're given this great opportunity to do just that, and to hear from an individual who has had experiences that many of us have not had. And I think these experiences are very, very important, particularly in our community where we find so many Black men incarcerated. And so I applaud the chairman for his boldness to move in this direction, and I support it wholeheartedly. Now to Mr. Caston, you got to do the right thing, and that is to help us to understand the sentencing process and why it is and can work for the District of Columbia. Thank you, Chairman.
Thank you, Councilmember. Councilmember Robert White.
Thank you, Mr. Chairman. I appreciate you moving this nomination forward. I've had the privilege of meeting Mr. Caston when he first came back to DC jail and have had the opportunity to work with him since then, but also to see his work. This is somebody who served his time to society and has come back to make a difference. When I reached out to Mr. Caston among the debate over his nomination a couple of weeks ago, it was hard not to feel bad that he and his family were cast into a difficult light because of assumptions, general assumptions made about returning citizens for a position that he didn't ask for. This is something the city requested of him. The idea of having a returning citizen on the sentencing commission among the judges, lawyers, law enforcement is a benefit to the city. It rounds out the perspective because we're not trying to be harsh. We're trying to get it right. Mr. Caston will help us get it right. I want to thank him for continuing to be willing to serve in this capacity. And I think, again, it will be to the benefit of the District of Columbia to have him there. So I look forward to voting in favor of his nomination.
Thank you, Councilmember. I just want to reiterate what I said. What's that? Oh, Councilmember Parker.
Yeah, there is not much more to add here. I do look forward to supporting Mr. Caston's appointment, but I think it is worth elevating that when Judge Lee came to share with the council who chairs the Sentencing Commission, and he was asked about this nomination, he spoke very favorably of Mr. Caston and emphasized the importance of perspectives like his. And so it's not just that members of the council think this is important and a worthwhile perspective and nomination, but someone from the Sentencing Commission. Thank you, Chairman.
Thank you. I do want to emphasize, even though 5 of the members are non-voting, and even though it looks like we're going to increase the size of the 17 members, this would be one of 17. The commission asked for this perspective. Looking at sentencing commissions in other states, they have been broadening the perspective they have on the sentencing commission. And as I said, when I was presenting this, the sentencing commission doesn't sit around and say, gosh, what should the sentence be for pick a crime, homicide? The statute says what the range of sentence can be. What the commission does is it looks at what judges have actually been sentencing and tries to find that midpoint, and that midpoint is actually fairly wide. It's not the bottom 25%, it's not the top 25%, it's what's in the middle, and those are the guidelines. And then the question is whether that continues to reflect what judges are doing, because they're not bound by the guidelines, so judges can depart, and the commission looks at where their departures, whether they should adjust the guidelines. It's really about ensuring that there is consistency in sentencing so that we don't take similar individuals with similar backgrounds and similar offenses and their sentences are widely disparate. That's what we want to avoid, because that's not really justice. So with that, we will have a roll call vote on the print. Mr. Cash?
Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
Yes.
Councilmember Fruman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Present.
Councilmember Nadeau votes present. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Mr. Chairman, there are 12 yeses.
Thank you, Mr. Cash. The print is approved unanimously with Councilmember Nadeau marked as present. I will move the report with leave for staff to make technical, conforming, and editorial changes. Is there discussion regarding the report? Hearing none by voice vote. All those in favor of the report, say aye. Aye.
Aye.
A little weak sounding, but we'll go with it. Are there any no votes? Don't see or hear any no votes. The report is approved unanimously. Madam General Counsel, is the measure legally and technically sufficient for our consideration?
Yes, it is.
Madam Secretary, is the record complete?
Once the report and hearing record are filed.
Madam Secretary, is the record complete? Madam Secretary, I didn't hear you. Is the record complete?
Sure. Once the report and hearing record are filed.
Thank you, Madam Budget Director. Does the measure's fiscal impact statement comply with council requirements?
Yes, it does.
This measure will be placed on the non-consent agenda for today's legislative meeting. If there's no objection, we'll take the next two items in block. They're both nominations by the mayor to the Corrections Information Council reported out of the Committee on Judiciary and Public Safety. PR 25-489, District of Columbia Corrections Information Council Governing Board, Charles Thornton, Confirmation Resolution of 2024. And PR 25-490, District of Columbia Corrections Information Council Governing Board, Prochelle Shannon, Confirmation Resolution of 2024. Councilmember Pinto.
Thank you, Mr. Chairman. PR 25-49 would reconfirm Charles Thornton as a member of the CIC Governing Board. Charles Thornton is the current chair of the board, and he currently works as a special assistant at the Office of Human Rights, where he focuses on ban the box initiatives. He has served in this capacity since 2016. Prior to his tenure at OHR, Mr. Thornton served as the director of the Mayor's Office of Returning Citizens Affairs, which assists over 5,000 returning citizens annually. While at MORCA, he oversaw the creation of training programs and resources for men and women who need assistance and marketable skills to successfully re-enter our communities. The nominee's confirmation resolution was unanimously approved by my committee at markup held on January 25th, 2024. PR 25-490, the District of Columbia Corrections Information Council Governing Board, Prochelle Shannon confirmation resolution of 2024 would confirm Prochelle Shannon as a member of the CIC Governing Board. Prochelle Shannon is the current CEO and co-founder of For Truth, a registered for-profit which provides trauma-informed consulting to private, nonprofit, and government entities. For Truth has provided services to the Department of Youth Rehabilitative Services during the 2021 and 2022 fiscal years. Ms. Shannon has over 16 years of experience working with incarcerated citizens in jails, prisons, reentry, and therapeutic residential treatment communities. She has served the population in many roles, most notably as a uniformed officer, substance abuse counselor, mental health therapist, management and program analyst, PREA coordinator, community corrections, senior institutional administrator, and former DOJ certified PREA auditor. The nominee's confirmation resolution was unanimously approved by my committee at a markup held on January 25th, 2024. I ask that both of these items be placed on today's consent agenda for the legislative meeting. Thank you, Mr. Chairman.
Thank you, Councilmember. Are there questions from members? These measures, we can only ask questions. Are there questions from members? I have three. Madam General Counsel, are the measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
Madam Budget Director, do the measures fiscal impact statements comply with council requirements?
Yes, they do.
And I believe there's never a fiscal impact statement on a nomination. However, I'm asked to ask the question. So without objection, these measures will be placed on the consent agenda for today's legislative meeting. There's no objection. We'll take the next three measures in block. They are also reported out of the Committee on Judiciary and Public Safety, and they concern nominations by the mayor to the Police Complaints Board. PR 25-510, Police Complaints Board, Paul Ashton, confirmation resolution of 2024. PR 25-512, Police Complaints Board, Derek Colbert, confirmation resolution of 2024. And PR 25-519, Police Complaints Board, Bobby Strang, confirmation resolution of 2024. Councilmember Pinto.
Thank you, Mr. Chairman. PR 25-510 would reconfirm Paul Ashton as a member of the Police Complaints Board. Mr. Ashton currently works for the Justice Policy Institute, a nonprofit organization that works to reform the criminal justice system and reduce incarceration. He has served 3 terms as a member of the Police Complaints Board since December 2014 and has served as chair of the board since October 2016. Mr. Ashton received his bachelor's degree in criminology with a minor in political science from Ohio State University. He later obtained a master's degree in criminology from the University of Delaware, where he also served as a graduate teaching assistant in the Department of Sociology and Criminal Justice. He is a Ward 5 resident. The nominee's confirmation resolution was unanimously approved by my committee at a markup held on January 25th, 2024. PR 25-512 would reconfirm Bobby Strang as a member of the Police Complaints Board. Mr. Strang currently works for the district government in the Department of Employment Services as a claims examiner. She administers informal conferences on workers' compensation claim disputes, issues memorandum and final orders regarding these disputes, and assists pro se claimants. Bobby Strang has served 3 terms as a member of the Police Complaints Board since November 2015. During her tenure, she has reviewed dismissals and participated in First Amendment assembly monitoring. She's a Ward 7 resident. The nominee's confirmation resolution was unanimously approved by my committee at a markup held on January 25th, 2024. PR 25-511 would confirm Derek Colbert as a member of the Police Complaints Board. Mr. Colbert currently works for the DC Workforce Investment Council, where he supports the expansion of the council's partnerships. Prior to that position, he worked as the Director of Operations for the Executive Office of the Mayor and the Office of Returning Citizens Affairs. In that role, he managed an 11-member team, evaluated operations, and developed community outreach programs. Mr. Colbert has also served as Associate Director for the District of Columbia of the Deputy Mayor for Greater Economic Opportunities, analyzing agency operations and recommending corrective actions to the agency director to improve customer service. This work included program audits and additional oversight. Mr. Colbert previously served as an ANC Commissioner for ANC 8C04 from 2013 to 2015. He is a Ward 8 resident. Mr. Chairman, I ask that all 3 of these items be placed on the consent agenda for today's legislative meeting.
Thank you, Councilmember Pinto. Are there questions from members? Madam General Counsel, are these 3 measures legally and technically sufficient for our consideration?
Yes, they are.
Madam Secretary, is the record complete for each?
Yes.
Madam Budget Director, do the measures' fiscal impact statements comply with council requirements?
Yes.
Without objection, these measures will be placed on the consent agenda for today's legislative meeting. Under other business, we have consideration of a schedule for the budget, but that schedule has actually not been finalized by the budget office, so it was not circulated. That explains why I didn't see it. So we will consider that at our next meeting, committee of the whole meeting, which is on February 20th. Since there's no further business, we will start the legislative meeting at 1:30. That's 12 minutes from now. The time is 1:18. This meeting is adjourned. I'm calling to order this meeting. This is a regular meeting of the Council of the District of Columbia. I'm Phil Mendelson, Chairman of the Council. Today is Tuesday, February 6, 2024. The time is 1:57 in the afternoon. This meeting is being held in room 500, the council chambers of the John A. Wilson Building. This is the 20th legislative meeting of council period 25. And it's our regular meeting for the month of February. We always begin our legislative meetings with a moment of silence. I would ask if members on the dais and everyone in the chamber would please respect a moment of silence for reflection. Madam Secretary, would you please call the roll?
Councilmember Allen.
Here.
Councilmember Bonds.
Here.
Councilmember Freeman.
Here.
Councilmember Gray.
Here.
Councilmember Henderson. Here. Councilmember Louis George. Here. Councilmember McDuffie.
Here.
Chairman Mendelson.
Present.
Councilmember Nadeau. Here. Councilmember Parker.
Here.
Councilmember Pinto.
Present.
Councilmember Robert White.
Present.
Councilmember Trayon White.
President.
Mr. Chairman, you have a quorum.
Thank you, Madam Secretary. I want to say at the beginning of this meeting, we have a lot of people in the chamber, which is great. We've all been through the pandemic. There were times when there was nobody in the chamber. It was kind of a bit sad. So I want to thank everyone for being here. There are a couple of issues that I know folks feel very passionately about. We do have a rule about decorum, so if folks would please, you can react however you want to, but do it quietly. That's what I want to say. Now we have, and we're going to get to that fairly quickly. We have the filing of committee reports and special reports. We have the secretary's report on committees. Mr. McDuffie, Chair Pro Tem.
Thank you, Chairman. I move to waive the reading of the Secretary's report.
Is there a motion to waive the reading of the report? Is there discussion? On the motion, all those in favor say aye. Any no votes? The ayes have it unanimously. We have the secretary's log of introductions and referrals. Again, I'll recognize the Chair Pro Tem, Mr. McDuffie.
And I will move to waive the reading of the Secretary's report of introductions.
Is there a motion to waive the reading of the report? Is there discussion? All those in favor say aye.
Aye.
Opposed? The ayes have it unanimously. We have the consent agenda. Are there any changes to the consent agenda? I do not hear any changes to the consent agenda. We'll have a roll call vote on the consent agenda, Madam Secretary.
Councilmember Parker.
Aye.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes, and Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The consent agenda is approved unanimously. Turn to the non-consent agenda on page 5. The first measure is final reading, Bill 25-350, MacArthur High School Designation Act of 2024. That came out of the Committee of the Whole. I am moving to recommit the bill to the committee. That is a motion to recommit. We can have a voice vote. All those in favor of the motion to recommit, say aye.
Aye.
Opposed? The ayes have it unanimously. The next measure, we're on first reading and vote on proposed bills, is Bill 25-56, Restaurant Revitalization and Dram Shop Clarification Amendment Act of 2024. This was reported out of the Committee on Business and Economic Development, chaired by Councilmember McDuffie. Mr. McDuffie, the floor is yours.
Thank you, Mr. Chairman. Bill 25-56 would clarify and codify into statute the district's dram shop liquor liability laws, which according to independent ratings organizations are impose the highest risk to restaurants, bars, and other establishments that serve alcohol in the country here in the District of Columbia. Our laws are in stark contrast to Maryland and Virginia, which do not permit civil dram shop liability claims against establishments. This bill aims to address the high insurance premiums which many establishments cannot afford and creates risk for both uninsured establishments and potential future claimants seeking to recover monetary damages. The committee print incorporates broad stakeholder feedback to clarify the scope of liability, ensure that those seriously harmed have access to justice, and bring down liquor liability insurance rates hurting the district's restaurants, bars, and nightlife establishments. This bill incorporates additional relief for restaurants, which Councilmember Allen and I have been working on. It streamlines managers' licensing and expands online workplace training. It regulates third-party meal delivery platforms, search algorithms. It excludes service charges from sales for the purpose of calculating rent pursuant to a commercial tenancy and narrowly defines service charges for the purpose of this new section. And it also requires executives to conduct a public education campaign regarding the District of Columbia Tip Credit Elimination Act of 2022, which is necessary given the complaints and confusion we have heard from consumers, workers, and restaurants about the tip credit. I'm moving an ANS today to align the provisions regarding delivery platforms to the emergency and temporary bills passed earlier this council period and to incorporate changes suggested by advocacy groups to the public education campaign regarding the tip credit. So moved, Chairman.
We have the amendment nature of a substitute before us. I circulated two amendments last night. They were recirculated today joined by Councilmember Bonds and Councilmember Pinto. The first amendment would establish a safe harbor in the law. Several restaurant groups have recently been sued over the service fee and our service charge, even though they are or say that they are complying with guidance issued by the Attorney General. We think that this situation is very unfair to those businesses, that they're complying with guidance and yet they're then getting sued. And so this is meant to help. At the breakfast, there was some discussion about trying to be a little bit more informative with regard to the disclosure, which the amendment I circulated has not yet accomplished. And the second amendment would change the implementation dates for the phasing out of the tipped wage and phasing to a full minimum wage without there being two wages, a minimum wage and tipped wage. I'm sure members understand what I mean by that. The initiative, when it was adopted, and I said at the time that I would not be supportive of any efforts to try to repeal that initiative. The initiative set that a gradual increasing of the tipped wage, which is driving restaurants crazy with regard to the year after year having to adjust their wage models. And what this amendment does is it advances by 2 years the date. So instead of the tipped wage going away in 2027, it would go away in 2025 with this amendment. That actually means that for restaurant workers who've worked for the next 3 years, they would receive an additional $12,000 in additional base wages. The catch is that, as members know, and we talked about briefly, there's some folks who think that this is actually a plot to delay the next step and then just repeal the initiative, which I am very clear and on record, and I don't know how many times I can say this, I will not support. And I am reasonably certain that members on the council would not support that. Nonetheless, these were circulated last night. I appreciate that Councilmember Pinto and Bonds joined me on this. What I'm going to do is I'm going to hold off on these until second reading so that there's a little bit more comfort with the Attorney General and his guidance and with the schedule, and maybe we can find a way to with a hot branding iron brand, that there will not be any subterfuge with regard to the initiative. So those amendments are withdrawn. Councilmember Louis George, you had an amendment you circulated. Do you still want to move those?
Yes,
The floor is
I only
yours.
have one amendment, yeah. Thank you, Mr. Chairman. I also circulated an amendment. I first want to thank my colleague, Councilman McDuffie, for his and his team's hard work and collaboration on the legislation, which will deliver important support to the restaurants that support our economy and communities. While I support the provisions of this bill that correct an expensive insurance requirements for restaurant and bar owners, there is one issue that I have regarding the service fee language that I think hurts both restaurant workers and customers alike. I think DC residents have spoken consistently and clearly. They want livable wages for DC restaurant workers in DC, and they want transparent menu prices when they dine out in DC. While embracing those goals, this bill provides, unfortunately, a financial incentive for restaurants to adopt service charges and to use those service charges to pay their workers base pay. This is the wrong policy choice for multiple reasons. First, service charges are at best very controversial. They can cause confusion and frustration among customers and are often not disclosed properly. In fact, it's so confusing that DC residents started a crowdsourced Google sheet to keep track of which restaurants have service fees, how they are advertised, and what they are used for. Based on this data from more than 250 restaurants, one district resident even built a Google Chrome browser extension that generates a pop-up alert when you visit the website of a restaurant with a service fee. It shouldn't be this difficult to go to a restaurant and order a hamburger. Second, service charges, when applied correctly, are supposed to take place of tips. But if we let restaurants use service charges to cover workers' base wages, then customers who are charged the service fee will be less likely to tip, and restaurant workers will make less in pay. These service fees are also a way for restaurant owners to increase their profits while reducing wages for their workers. We should be encouraging restaurants not to use service charges, not providing a financial incentive for even more restaurants to use service charges. Third, the FTC is preparing to prohibit restaurant service charges through a new rule. It is drafting that bans junk fees. We should not be doubling down on a service charge model that the Biden administration is about to render illegal. And it's not just the Biden administration. The Office of the Attorney General also issued guidance just last year to address confusing service fees when they may violate the district's Consumer Protection Procedures Act, and several DC restaurants who were sued by consumer advocate groups over service fees immediately eliminated those fees. The bill did not invent service charges, but it provides a financial incentive only available to restaurants who adopt service charges and have a specific type of lease. If I know you have heard from restaurant owners saying that tips are not counted in rent calculations, so for service fees shouldn't either. Chairman, I'm going to ask for additional minute.
Can it be 30 seconds and without objection?
I know you've heard from restaurant owners saying that tips are not counted in rent calculations, so service fees shouldn't either. That makes sense, and I agree. When a service charge operates like a tip on top of base wages. Bryan on H Street Northwest is a perfect example. They have a 20% service charge that goes to workers on top of base wages. They deserve a break on their rent for that, and my amendment would give them one. But when a service charge is not like a tip, when it covers base expenses, the restaurant shouldn't get the rent break. If this amendment fails, more restaurants will create service charges that simply cover base wages, as you heard today from over a dozen tip workers, that puts their tips and livelihoods at risk. I also know you're concerned about service charges in general, and you have a good reason to be concerned. The tip workers who visit your offices have many horror stories to tell, and the underlying bill will expand the number of restaurants using service charges that are bad for workers. My amendment will not contribute to the expansion of service charges, and it starts a conversation about the right way to limit service charges so that customers and workers are protected. The bottom line is these fees are not transparent, and anyone who sees a service fee of 20%, that's a tip. If restaurant uses a service fee for base wages, they are
Councilmember, you asked for an additional minute. You're over your time.
Oh, I didn't see
that.
that.
McDuffie, did you want to respond?
I have 4 seconds left.
If I could, Chairman, and I know there are some other folks who are interested in this measure, and frankly, and rightly so, have concerns about service charges, as do I. I would ask my colleagues not to support this amendment. It was my hope that Councilmember Lewis George might withdraw her amendment in order to try to work through some of the challenges that get to the heart of what it sounds like her issue is with service fees. I know other members similarly have concerns around those fees, but this amendment, the way it's presented today and the provision to which it would attach itself would entirely reverse the help that this provision would provide some district restaurants. It takes money out of the pocket of our local restaurants and their employees and actually puts it into the hands of mostly large commercial landlords that aren't our constituents. Many, if not most, restaurant leases provide for rent to have a base rent plus a percentage of gross sales. The lease nearly always allows the tenant to exclude certain things from their calculation of gross sales. For example, sales taxes, tips, amounts received for sale equipment, and things like that. With many leases having been signed before the passage of Initiative 82, those leases are ambiguous about how service charges that go to employees are treated. This would control where that ambiguity exists or it doesn't speak to what's supposed to happen. Under this bill, the landlord and the potential tenant can still bargain for whatever they like as it relates to how service charges are used in a rent calculation. This only speaks to the presumption when the lease is silent on the matter. It allows restaurants and landlords to avoid potentially costly litigation over the meaning of the lease. It also prevents an unattended windfall to landlords from the increased labor costs associated with Initiative 82. And so my ask, given how much time we've put into this and how we arrived at this point, it's been a give and take process. As you all remember, this bill looks a lot different than what it did as it was originally introduced. And it's really gained a lot of support and traction amongst advocates, amongst people in the industry, restaurants, workers, and my colleagues. So I would ask that you not support this amendment and that we give some thought between first and second reading as to how we better address the issue around service fees that I think are at the heart of what this amendment is trying to solve for.
Further on the amendment, Councilmember Parker.
For Councilmember Lewis George, I appreciate your concern for workers and this idea that incentivizing more restaurants to adopt service fees at any amount could ultimately hurt workers. I do have a question, and that is around enforcement. So assuming your amendment is adopted, how do you foresee the district enforcing or managing that restaurants are not including base wages in their service fees? And I would also say before you respond, sorry, that I think what is also at the root of the problem here is that we ought to weigh in on capping service fees. I know I've engaged with the Restaurant Association. I've had conversations with Councilmember McDuffie. That is something I am looking to work with the committee on ahead of second read, and I would invite you to join me on that because I think that could get at some of your concern around how do we not incentivize more workers or restaurants of adopting service fees at exorbitant amounts that ultimately hurt workers. But I would love to hear your thoughts on how we enforce your amendment.
Yeah, and my thoughts is the Attorney General Office is already doing enforcement around wage theft. It's already talking about the issues around consumer protection and due consumer protection claims. So from an enforcement, OAG has issued guidance, and I think we need to listen to the experts on that piece. So as far as enforcement, I would say the Attorney General's Office has the ability and has been doing so actively through consumer protection claims as well as wage theft. In that regard. And I'm happy to work with you all on second reading in that regard. I think my only large question here is sort of how is the language regarding service fees not an incentive for restaurant workers to charge service fees and raise them as high as they can get away with? And I guess what you're saying is you're looking at possibly capping that so that wouldn't be a possibility if I'm understanding what you're thinking about for amendment. And so
yes, that is what I'm interested in. I am sympathetic to what you're getting at in your amendment. I just keep coming to the question of how do we know? how do we, like, who's overseeing this? Who's managing this? I know you're speaking to the Attorney General. It's worth in my last 30 seconds also pointing to the fact that there are or were amendments seeking to adjust consumer protection laws for our restaurants. I also think we should be skeptical of any efforts to shift dates, whether it's backwards or forwards. But I appreciate your effort and for taking time to answer my question, but I still am left with the, how do we enforce this?
Thank you, Councilmember. I want to interject at this point. I think there's some misunderstanding. The amendment applies to a section in the bill that deals with leases. And I'm hearing a lot of discussion about service charges and whether service charges are appropriate and whether service charges should be used for tips or for base operations or whatever. That's just not what this section's about. The section has to do with leases between the restaurant and the landlord. Councilmember Allen,
Chairman, if I could,
no.
okay,
You've
well,
been-
it was
you've
gonna make,
already
it was gonna make
spoken.
the day, it was gonna make the day shorter, but go ahead.
Oh, if you're gonna
Thank you.
withdraw it, are you withdrawing it?
No, she should withdraw it after I speak.
I'm gonna say, sorry, Charles. Yeah, Chairman, I'm willing to withdraw my amendment right now and work with Councilmember Parker and Councilmember McDuffie to see if additional language can fix this. And so I move
All right,
to
so
it.
the amendment is withdrawn. Thank you. We have the amendment nature of a substitute before us. Let me just say that if I'm sounding a little tight with the time, I am a little tight with the time, and I'm going to try not to get distracted and let my eyes wander away from the clock. Everyone needs to pay attention to the clock. We got a long meeting, a lot of amendments. If 10 people speak for 3 minutes on one amendment, that's 30 minutes just on one amendment. So I'm going to try to stick to the clock. And with that, we have the amendment nature of a substitute. I think there is still further discussion. Councilmember Allen.
Sounds like democracy. I love it. Thank you, Mr. Chairman. I want to just speak in support of this amendment in the nature of a substitute. I want to thank my colleague, Councilor Lewis George, even though she's already withdrawn it, that she was going to come back and work on it for a second reading. I felt like you were maybe reading from my notes when you spoke, Mr. Chairman. But I want to note one thing that I want to thank Mr. McDuffie for that's in this ANS in particular is as we included a lot of elements of several bills, one of which I had authored. One of those was around the outreach and education campaign. And one of the things that we heard from a lot of our workers was to ensure that that was going to include workers as part of that component. I know, Mr. McDuffie, you added that in, and we talked about that before. So I just wanted to note my appreciation for making sure that that language was changed up a little bit to be included there. So with that, I definitely encourage my colleagues to support this ANS, and it sounds like there'll be more collaborative conversations moving towards the second and final reading as well. Thank you.
Thank you, Councilmember. Councilmember Fruman.
Thank you very much, Chairman Mendelson. And I very much want to thank Councilmember McDuffie for coming forward with this bill. One of the pieces that's very important is the changes around liability and bringing the trial lawyers and the Restaurant Association together around a shared approach is really something to be lauded. On this service charge issue, I hear you, Chairman Mendelson, that this is about a very narrow piece of the whole calculation, and it's just about the rent. But what it is a blessing of using service charges both for base costs and for tips. And that creates a lot of confusion. And I think I was going to support Councilmember Lewis George's amendment because it would be clear the service charge is just about tips. But the key thing is, whatever it is, it needs to be clear to the consumers what their service charge is for. We hear that from the FTC. We hear it from the guidance from the Office of the Attorney General. So I'm going to support this ANS, but I really think it's important that on all of these pieces between this first reading and the second reading, we come to an approach that provides for clarity, not just it could be this, it could be that, but clarity about what it's for and to what extent it's for certain things. We can do it. It's not that complicated. It's not that hard to enforce. Restaurants keep their books. They will know exactly how much they had gotten from service charges. They will know how they spent that money. We can, this is not like rocket science. This can be achieved. We can get to clarity. And if we don't get to clarity, then I don't think you should kid yourself about lawsuits going away, because without clarity, that's the basis for lawsuits and they'll happen. So let's get to clarity for everyone's sake between the first and the second reading.
Thank you, Councilmember Pinto.
Thank you, Mr. Chairman, and thank you so much, Councilmember McDuffie, to you and your team for advancing this bill. Our restaurant and nightlife industry is a critical piece of the district's economy, with over 2,000 restaurants and 45 performing arts venues employing tens of thousands of employees and serving millions of residents and visitors every year in the district. Our restaurants reflect the diversity and creativity of our residents, and they're a key part of what makes the district such a vibrant, culturally rich place that attracts residents and tourists from around the world. We all know that the pandemic was especially devastating for so many of our local and beloved restaurants, and as they continue to rebound, we must consider how to ensure the district supports our existing restaurants and provides a competitive environment for new restaurants to locate here. Liquor liability insurance in the district is prohibitively expensive, leaving many businesses to go without coverage. Without coverage, businesses are vulnerable and potential victims may be left with limited financial recourse when they have injuries stemming from violation of our liquor license laws. I introduced the Dram Shop Clarification Amendment Act to clarify and tailor liability so that we can reduce insurance premium costs and increase uptake of coverage by our local businesses. The bill will bring us more in line with other states' Dram Shop laws while ensuring that potential victims have substantive recourse when violation of the law does occur. This bill also advances several other provisions from bills introduced by our colleagues, Councilmember McDuffie and Councilmember Allen, that will clarify laws around food service delivery platforms and clarify treatment of service fees specifically for the purpose of determining lease payment rates and educate the public on the phase out of the tipped minimum wage. It will also improve protections for food service delivery workers and study additional support that may be needed for these workers. I also want to thank Councilmember Henderson for introducing the Dram Shop bill with me and her continued partnership. This bill will provide meaningful relief for our restaurant and nightlife industry while protecting our workers and residents. And I look forward to supporting this bill today and urge my colleagues to do the same.
Thank you, Councilmember Pinto. If there's no further discussion, the vote is on the amendment nature of a substitute and then on the bill as amended. On the amendment nature of a substitute, all those in favor say aye.
Aye.
Are there any opposed? I do not hear any no votes. The ANS, the amendment nature of a substitute, is approved. We have the bill as amended. Is there further discussion? We'll have a roll call vote on the bill as amended.
Councilmember Pinto,
Yes.
Councilmember Pinto votes yes. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White,
Yes.
Councilmember Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Fruman,
Yes.
Councilmember Fruman votes yes. Councilmember Gray,
Yes.
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson,
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes, and Councilmember Parker.
Yes.
Councilmember Parker votes yes. Mr. Chairman, there are 13 yeses.
Thank you, Madam Secretary. The bill is approved as amended, first reading. We'll turn to Bill 25-345, Secure DC Omnibus Amendment Act of 2024. Councilmember Pinto.
Thank you very much, Mr. Chairman. Today, I am moving Secure DC Omnibus, and I'm moving this bill along with an amendment in the nature of a substitute. In 2023, we saw a devastating 39% increase in violent crime and 26% increase in crime overall in the district. 274 people lost their lives to homicide. Residents are in fear of carjacking, thefts, and falling victim to crime across our city. This is unacceptable. Today, by approving my Secure DC Omnibus, the council has the opportunity to take decisive and comprehensive action to make the district safer and more secure. Our residents deserve to feel and be safe in all of our communities. Every day, I, along with my colleagues, hear resounding calls from residents, government partners, and advocates to urgently address this crisis in an urgent, comprehensive, and sustainable manner. Secure DC includes over 100 targeted interventions to answer these calls and fill critical gaps in our public safety ecosystem to prevent crime and end cycles of violence, to increase accountability when crime does occur, and to enhance government coordination and oversight. Throughout last year, I heard from and met with literally thousands of residents and advocates through over a dozen public hearings on each of the bills included in today's omnibus, community meetings and forums, public safety walks in all 8 wards, and dozens of meetings. These discussions all informed the legislative process and affirmed that Secure DC will help turn the tide on the crime trends that have overwhelmed our communities. I also worked closely with each and every one of my colleagues, thank you all, to make technical, clarifying, and substantive revisions to the legislation to ensure the efficacy and implementation of Secure DC will make the greatest and most sustainable impact on the livelihood of district residents. I deeply appreciate the input and partnership of Mayor Bowser as well, including MPD, our USAO, the courts, PDS, and many of our district agencies in ensuring that these ideas are responsive and are implementable. Many residents and advocates have offered passionate and well-reasoned arguments in favor of our city doing much more to address the root causes of crime. I strongly agree that addressing the root causes of crime is critical in reducing violence. This bill addresses what the Committee on the Judiciary and Public Safety has oversight over, and I look forward to continued partnership to address additional needs with the chairs of other committees and all of our colleagues. With that said, the robust public engagement process the Committee on the Judiciary and Public Safety convened throughout the last year makes me confident that Secure DC will make district residents safer and more secure. A number of provisions, Mr. Chairman, may I have some more time?
1 minute. Well, she is the mover of the bill, 90 seconds.
I need to speak about some of the ANS components. So
2 minutes without objection.
thank you, Mr. Chairman. A number of provisions focus on preventing crime, including providing grants to non-governmental organizations, investing in reentry for and training for our returning citizens. Other provisions focus on greater enforcement and accountability. Without swift and certain consequences, we will continue to see the lack of sense of accountability that has contributed to the current circumstances in the district. These proposals focus on deterring the small number of individuals who are repeatedly engaging in violent crime and temporarily and securely holding the most dangerous individuals to prevent more harm from our communities. I also want to note that along with the many residents and advocates who engage with the committee, I remain concerned about the impacts of incarceration on the most affected communities, and I'm concerned that Black and Brown residents are disproportionately represented in our incarcerated population. I'm also concerned about the disproportionate impacts of crime on Black and Brown residents and on neighborhoods that are low income and underserved. I believe that greater enforcement and accountability, along with greater prevention and coordination efforts, are necessary to make the district safer and more secure with all of our residents. So let me move on to the ANS briefly. Today, I'm moving an amendment in the nature of a substitute, which will make several changes to the bill. I'm not going to go through all of them, but just to highlight a number of them. On policing, the ANS returns to allowing FOIA requests for unsustained allegations to officer misconduct. On DNA, the ANS moves analysis of DNA to after charging or a probable cause finding. On drug-free zones, we made a number of changes around the notice requirements and reporting structures, as well as additional changes to other provisions in the bill. With that, I move the amendment in the nature of a substitute for the Secure DC Omnibus Amendment Act of 2024. And thank you again to all of my colleagues and to my entire team for the humongous effort and involvement and engagement in this bill.
Thank you, Councilmember Pinto. So we have the amendment nature of a substitute before us. We have a number of amendments that have been circulated. We're going to turn to the amendments, which would be amendments to the amendment nature of a substitute. Once we're done with all the amendments, we will then vote on the amendment nature of a substitute. So I'm going to call on Councilmember Nadeau first.
Thank you, Chairman. In our pursuit of public safety, it's imperative that we adopt a balanced approach, one that comprehensively addresses the intricate challenges inherent in law enforcement endeavors. Among these challenges lie the crucial task of closing cases, particularly homicide cases, which demand our utmost attention. In November, I introduced the Case Closure and Witness Support Amendment Act of 2023, a more robust version of an amendment, the amendment I'm offering today. Today's amendment is aimed at giving MPD the tools it needs to close more homicide cases successfully. The core of this amendment involves a significant increase in the reward for witnesses in homicide cases, ensuring they receive at least $50,000. Right now, the most they're paid is $25,000. This adjustment is crucial because law enforcement and prosecutors often encounter challenges in building cases due to the reluctance of witnesses to come forward. With a DC homicide closure rate at only 45%, we need to encourage more witnesses to come forward. Nationally, the average clearance rate tends to hover between 50 and 60%. A low rate of solving cases, especially homicides, can make police feel demoralized and make people in the community trust the police less. This loss of trust can make it harder for police to work with public to solve crimes. The increased reward not only encourages them to share crucial information, but also provides the means to safeguard themselves, whether it be relocating to a safer place or taking other necessary precautions. Some of my colleagues have asked me, does this even work? Among several studies, the Bureau of Justice at DOJ published a multi-year study in 2018, which found the successful homicide units use a reward system, and these systems must be appropriately funded in order for people to come forward. The study found that many successful homicide units who have incorporated such systems have witnessed a positive impact on their efforts to solve for the cases. My amendment also calls for a study on the extent and effectiveness of the district's programs and policies for witness protection and assistance. While there are already witness protection and support programs in the district coordinated by the U.S. Attorney's Office, there's no law whatsoever that establishes the program or its goals and responsibilities. And as a result, we have no way of knowing whether this critical public safety need is adequately resourced. The amendment includes a provision which allows the CJCC to prioritize the safety and security of those individuals by restricting the sharing of information in the study that could put anyone at risk. Confidentiality is a top priority, and the study doesn't focus on individual cases, but examines broader outcomes to understand the effectiveness of witness protection programs more comprehensively. Money alone is not the solution, of course, but through the bolstering of witness cooperation and through evaluation of witness protection programs, we can propel forward public safety initiatives and cultivate heightened trust in our justice system. I am actually interested in working together with Councilmember Pinto and other members of the council to get this amendment in a place that everyone feels comfortable with. And so I intend to do that work between first and second reading. So today I will withdraw this amendment. Thank you.
Thank you, Councilmember. So the amendment is withdrawn. I'm going to turn to Councilmember Henderson next. Do you have an amendment?
Yes, Mr. Chairman. Sorry, I didn't think I was next. Thank you. I'm moving an amendment today that was circulated earlier and then including the legal sufficiency in the FIS, to address some concerns about the potential consequences of haphazard enforcement of the anti-mask provisions that were included. This amendment strikes the language that causing a person to fear for their personal safety as culpable intent of a person wearing a mask or a face covering. So if you think about it, if I'm out living my life in public and I'm wearing a mask and I walk past a person who for some reason fears me, I could be arrested under those provisions, even if that was not the intent. I have done nothing nefarious or anything threatening, but how could I prove that that wasn't my intent to cause you fear? What's the standard? So I think logically that paragraph 4, which includes intimidation, threatening, abuse, or harass another person as culpable intent, clearly captures specific behaviors that would actually cause someone to fear for their personal safety. And so I hope that this amendment could be accepted as a common sense clarification for our intent here.
Councilmember Pinto.
Thank you, Mr. Chairman. Thank you so much, Councilmember Henderson, for for this amendment. I want to make sure it is very clear to all those in the public that wearing a mask, wearing any sort of facial covering for whatever purpose on its own is absolutely not prohibited, never was prohibited, never was the intention of Security C, never was the intention of any ANS or in the language. So that has always been consistent, and is really important that everybody in the public is aware of that. I do think what Councilmember Henderson is introducing clarifies around the intention for causing fear, and I will accept this amendment as friendly.
It could be accepted without objection. So if there's no objection, the amendment will be accepted. Hearing no objection, the amendment is accepted. Councilmember McDuffie, you had an amendment, although, give me just a moment. Councilmember McDuffie.
Thank you, Chairman. And I will reiterate my thanks to Councilmember Pinto and her team for all the hard work that went into this bill. Even in instances where members don't agree on every single aspect, I think it's important to recognize how much work goes into this process. And I think it's fitting that we do that. Now, I do have an amendment that was circulated out. In my amendment to this ANS would eliminate the expansion of DNA collection and restore it to current law. Under the ANS, law enforcement would be allowed to collect DNA samples from individuals upon arrest. Currently, over half of arrestees are never charged with a crime by the United States Attorney's Office for the District of Columbia. Therefore, such collections subjects thousands of individuals to intrusive and unnecessary collections of their private biomedical material. And the expungement provisions of the ANS will not adequately protect arrestees because once their DNA has been entered into CODIS, other jurisdictions will have access to their data. Proponents have said that over 30 states collect DNA at arrest, but that's not quite the full story. Very few states collect DNA at arrest for all felony and other crimes as this bill proposes. This provision puts us in a company of amongst states that do it, Louisiana, Alabama, and South Carolina. In 2009, when the Committee on Public Safety and Judiciary last considered changes to expand DNA collection, the committee report said, and I'm quoting here, expanding the government's net of DNA collection may lead to low stringency or familiar searching of DNA data banks. The committee believes that privacy rights of the innocent should be preserved. And I think that bears repeating. The privacy rights of the innocent should be preserved. And let us not forget, we are all innocent until proven guilty.
So, members of the audience, please refrain from applause.
Nothing has fundamentally changed in the 15 years since that conclusion is written. Crime has gone up and crime has gone down in the time since that's been considered. Finally, just this past week, a lawsuit alleged that hackers hacked the DNA database of 23andMe to specifically target people of certain heritage. The Wall Street Journal wrote extensively about the company's uncertain future, despite its stockpile of 10 million DNA samples. We should be uneasy about collecting and storing DNA without probable cause, because once it is collected, it will be used in ways that we do not envision or necessarily intend. But we are being asked to effectively sanction those future uses today. So I appreciate the opportunity to move this amendment. And I would like to request, actually, you know what? I move the amendment.
Thank you, Councilmember McDuffie. Councilmember Pinto?
Thank you, Mr. Chairman. Thank you very much, Councilmember McDuffie, for moving this amendment and raising the concerns that you have raised. I think as we seek to prevent crime from happening, it is very important that we think about the tools that we have before us. 31 states collect DNA evidence in this way. I know you listed some Republican states, so does Maryland, so does Colorado. So I don't think listing other states that do this testing is necessarily persuasive. There are a number of examples where somebody was arrested for an offense, was not ultimately convicted for an offense. Years later, was arrested, charged with another offense, was not convicted for that offense. And then in the third instance, was arrested, charged, and convicted, and turned out they had committed all three of the offenses because we didn't have their DNA until the third time. That would have prevented crime. And as we think about the balance that is important to all of us as we move forward, we cannot forget the balance of victims' rights. Victims are being harmed greatly, and we can prevent crimes much more effectively if we have access to this information. This is not a novel concept. This is done by over half of the states in the United States. There was a study in Denmark that had a similar DNA database. They found DNA registration reduces recidivism within the following year up to 42%. And increases the probability that offenders are identified if they recidivate. The bottom line is expanding government DNA databases to add more criminal offenders is a big deterrent effect, which reduces the number of crimes that will be committed. There's also a practicality concern here of making sure there's a practicality concern here of ensuring that the swabs can be taken at arrest when we have access to somebody who is being arrested for booking, for their fingerprinting, and to take this swab. I think this is a really important provision to move forward. I ask colleagues not to support this amendment today.
I'm going to ask. We can clear the chamber, which I really don't want to do, but this is not a public meeting. I'm sorry, but this is a meeting of the council that's open to the public. And it's unfair to the speaker, in this case, Councilmember Pinto, that there's all this noise in the chamber. It's just not fair. So again, I ask that there be decorum. Councilmember Pinto, were you done with your statement? I do want to note, I didn't complete this list, but there are far more than 3 states that take DNA at booking for all felonies. And in alphabetical order, but I didn't finish the list here. It's Alabama, Arizona, Arkansas, Colorado, Florida, Indiana, Kansas, Louisiana, Maryland, Michigan, Missouri, Nevada, New Mexico, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Texas, Utah. So that's many more than 3 states. Does anybody else want to speak on this amendment?
That's not.
Councilmember Lewis, George, did you want to speak?
Yes, I wanted to speak in support of Councilmember McDuffie's amendment. He has made most of the arguments. I think these changes are necessary not only to protect privacy and due process rights, which he has already noted, but also to ensure that our forensic resources are focused on helping us solve the crimes in which DNA evidence is most useful. The district does not possess unlimited resources to process DNA samples. The interim director for DFS testified at the agency performance eye hearing just last week that it currently takes an average of 69 days to process sexual assault kits, which is already 9 days longer than the 60-day period required by the law. We had more than 1,700 charged felonies last year. 5 years ago, we had more than 4,000 charged felonies. If DFS were to process DNA for all charged felonies, there would be a massive increase to its existing backlog, and it would take even longer to process the DNA evidence we are already collecting. The district's limited resources to analyze DNA samples should be targeted to the cases in which DNA evidence is most likely to be valuable, which are our sexual assault cases. In these cases, DNA sample collection should be required and not optional. I think it's important that as we do this work, for all the reasons that Councilmember Duffy already reiterated, that it is important for us as we move forward to understand the surest way to protect our constitutional privacy and due process rights would be to continue requiring law enforcement to obtain a warrant before collecting a person's DNA if they have not yet been convicted of a crime. And so I just join my colleague,
McDuffie, not only for the practical reasons, but also the real constitutional privacy and due process concerns. Thank you.
Thank you. Further on the amendment? Councilmember Allen?
Thank you, Mr. Chairman. I'm supporting this amendment, and I appreciate my colleagues' comments on it. To kind of pick up where Councilor Lewis George was, we're currently, Department of Forensic Sciences has a close to 1,200 case backlog of uploading DNA into our CODIS system. So the sheer magnitude of what it would take, I don't think would deliver the promises that this amendment perhaps is, or the underlying language is perhaps promoting. What I think could make a difference is helping preserve the rape kits that we have already stored at the Washington Hospital Center that are tossed out after 2 years. That type of work can help make sure that that DNA evidence can be preserved and be able to be used for future prosecutions of someone who commits sexual violence. But I think that this amendment is both the right thing to do from just a practical standpoint of what our Department of Forensic Sciences, as it tries to regain its footing and get its accreditation back, can do. In addition to, I think, kind of our underlying philosophical arguments that have been laid out about why it is that we don't take DNA at the point of arrest, and instead at the point of conviction. Thank you, Mr. Chairman.
Thank you, Councilmember Allen. If there's nothing further, Councilmember Pinto, second round.
Thank you. So a couple things. First, no analysis will be done under how we have it in Secure DC until after probable cause hearing. The swabbing is just a practical necessity to happen at booking. And the analysis of the DNA sample doesn't happen until after the probable cause hearing. Second, to Councilmember Allen's concerns about DFS, DFS was just approved to upload to CODIS, and so we're expecting that the backlog will be significantly reduced, and they're hiring more staff to do this as well. To have additional machinery to make it move forward. With that said, I sense some consternation among colleagues. I want folks to have a chance to have their questions answered about this, to work together. I would ask you, Councilor McDuffie, to withdraw this amendment, and we can work together between first and second reading on components of both the category of cases and, as we discussed at the breakfast, around probable cause hearings versus probable cause determinations. But I think that this is very, very important. And as we think again about our tools to prevent crime and be responsive to what we're seeing, which also is progressive crimes happening. We need to be able to prove crimes earlier so that the more serious crimes don't happen later. I think this is really important. And so I ask you to withdraw this amendment so we can work together between first and second reading and see if we can come to a compromise.
I appreciate that, Councilman Pinto. I do sincerely, but I think we should allow this vote to take place on this matter right now. As you know, well aware, and we've had a number of conversations, and I perhaps didn't credit you enough. You know, both you and I, but also our teams have talked extensively, and there are some things that you have accepted in your ANS in terms of modifications that I suggested, and so I appreciate that. But for this purpose, for this amendment, I would like us to go to a vote, and I would ask the chairman for a roll call.
If there's nothing further, Madam Secretary, will you call the roll? The vote is on the amendment that Councilmember McDuffie circulated with Councilmember Lewis George.
Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Fruman.
No.
Councilmember Fruman votes no. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
No.
Councilmember Henderson votes no. Councilmember Lewis George.
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
No.
Chairman Mendelson votes no. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
No.
Councilmember Pinto votes no. Mr. Chairman, there are 9 yeses and 4 nos.
Again, I appreciate the passion. These are important matters, but we really need order in the chamber. The amendment is approved. The next, give me just a second here. Councilmember Bonds, you were next.
Thank you very much, Chairman. Today I had several amendments that I wanted to present to the body as it relates to the Secure DC bill, and all the 4, one I want to move forward with, and that is the bill that will speak to adding in, I think it's sorry, my papers are a little confused here. Turn to my copy here. It is the amendment number 2, and this amendment seeks to expand the crimes covered in this section by including crimes of coercion and unlawful entry. These crimes are among those most often committed against seniors and adults of declining capacity. It's important to ensure that these crimes are included in any penalty enhancement that concerns our senior citizens. As people reach advanced age, individuals with bad intentions may attempt to gain access and use of their property. By designating these 3 crimes as those that are covered by this provision, we will provide greater protection to our senior community. Mr. Chairman, I have to ask to do an oral amendment to strike the inclusion of trespassing, as trespassing in itself is a non-violent misdemeanor, and it's in the original amendment that I was attempting to move today. And with that, I'm asking for my colleagues' support, asking that colleague Pinto accept this as a friendly amendment.
Councilmember Bonds, so you're moving your amendment number 2, and
Yes.
you're striking from it the word trespassing.
Correct.
We have the amendment before us. Councilmember Pinto?
Thank you, Mr. Chairman. Thank you so much, Councilmember Bonds. I share your passion and desire to protect our seniors. Unfortunately, I can't accept this amendment as friendly today and don't think we should move forward on it for a number of reasons. First, Secure DC adds penalty enhancements when a senior is a victim of a crime of violence. This went through a public hearing process. We worked with lots of stakeholders to make sure that it was balanced throughout the code. And I worry about tacking on penalty enhancements at this hour without that full public process and without an understanding of how it's going to affect everything else in the criminal code. And so while I remain committed to working with you on protecting our seniors in a number of ways, I can't support penalty enhancements that we haven't been thorough and thoughtful about all of their consequences. And so unfortunately, I can't support this amendment today.
I'm going to join with Councilmember Pinto on this. And the reason I'm speaking up is because, and I appreciate Councilmember Bonds that you struck trespassing, but coercion is also not an offense that's recognized in our criminal code. So to add coercion is essentially meaningless. And then unlawful entry is in our criminal code, but my understanding is it's a misdemeanor. And the chances of there ever being a sentencing enhancement on a misdemeanor is slim. Now, it may be that there's some way that you can get to what you want, Councilmember Bonds, between now and second reading, but I think this amendment before us is problematic. Simply because coercion is not recognized and unlawful entry is a misdemeanor. Is there any further on this amendment?
Mr. Chairman.
Councilmember Robert White.
Thank you, Mr. Chair. I want to understand this amendment. Councilmember Bonds, is this amendment to increase penalties for various crimes against seniors? Or is it to address an issue of people squatting in the homes of seniors and them not being able to, feeling like they can't do anything about it, being prisoners in their homes?
To Councilmember White, as we have discussed, it really is to address both situations. One of the conditions in our community today is that seniors are easy prey. And as a result, it was very strong feeling in talking with many of the senior groups that there needs to be more done to protect them. And the idea of trying to put additional protections in this current omnibus bill is why we have included this language today. Coercion may in fact not be in our criminal code. Maybe that speaks to why our criminal code needs to be updated. But it is certainly a situation that people are constantly faced with, particularly when we talk about their property. There are situations where individuals have been helpful to a senior, and then they don't know how to leave after they drop the bag of groceries. They continue to be there. And there have been incidents where seniors have been forced to just sort of leave the situation as it is and have to put up with even drug trafficking from their home. And so I'm trying to address that. And perhaps, you know, the language may not be as exact or precise as we are trying to make it today, but I'm here to say for the senior community that something has to be done. And we have to give respect to this process. And if this is the law that we are examining today, I am saying, why not include senior concerns in the law? So that's where I'm coming from. Well, thank you. And thank you, Chairman.
Thank you. Councilmember Fruman.
Thank you very much. And Councilmember Bonds, thank you for all of your work on behalf of seniors. I do share some of the concerns that have been expressed about what does this actually mean as implemented. As I read the language, it's not limited to seniors. It happens to be a set of crimes to which seniors more typically fall prey, but it applies to everyone. And crimes of violence, as I recall, we made changes about presumptions of pretrial detention in the setting of crimes of violence. And so this is, I think, broader. Your goal of protecting seniors, I share. This is broader than that, taking a whole new category of offenses, putting it into a world of enhanced penalties, presumptions of pretrial detention. I would want to think about that more than I've had the opportunity to do today. So I think this is the thing, we could look at ways to enhance protections for seniors, but I'm not sure this does it today. And so I won't be supporting the amendment.
Mr. Chairman, no?
No,
I
I'll
would be able
recognize
to
you. Can,
respond-
yeah,
To respond to him? No?
let me call other members and then I'll recognize you. Councilmember Allen.
See.
Thank you. And Ms. Bonds, I'm going to ask a question, so that'll give you a chance to respond. I appreciate the intent here. And what I was going to do is kind of make sure I understand the intent behind it. So I know in Ward 6, for example, I've had to work with constituents where a senior is, for all intents and purposes, feels trapped in their home and fears for their safety or whatever the family dynamics are at play or other household members at play, that vulnerable senior is feeling threatened and unsafe. If I understand, and I think I am, the intent behind what you're trying to do here is to try to create new tools to help be able to remedy that situation, be able to help make sure that senior is safe. I think that's what I'm hearing. And I do think I hear a little bit of trepidation just about exactly how to get the phrasing exactly quite right. And I know since we have second reading coming up, perhaps this is an area where we can keep working on for second reading. But if I understand the intent correct, I understand it. And I think a lot of folks share a goal of trying to help protect that vulnerable senior. So I'll give you a little bit of my time if you want to help talk a little bit more about the intent behind it, and then whether maybe there's some work to be done for second reading as well, if that'll help allay some of the concerns from folks.
Thank you, Councilmember, Allen. You are, right on the dial. The intent is to utilize, as I said at the beginning, to utilize this omnibus legislation to really put in place a tool that will begin to address this issue. And so I am very willing to pull it today. But I am insisting, and I think the community is insisting, that we have something in place to handle what happens in our senior community. And so I will not stop on that point. I will press on, and I'm willing to work with the chairman, obviously, and with Councilmember Pinto to make it right for the second reading. And so that's where I'll land. So I will withdraw it, but I wanted it to be aired today so people understand that this is in fact a real issue. We give very little attention to it. We know it happens in neighborhood after neighborhood. And so I'm not going to let go of the issue one way or the other. So thank you.
So are you withdrawing this today?
Yes.
All right. Do you have anything further, Councilmember Bonds? Then, Chairman. Next would be Councilmember Louis George. Yes, dismissed. Councilmember Louis George, are you ready? You would,
I'm ready. Thank you.
circulated 3 amendments that are linked on the agenda.
Correct. Amendment 1, I will like to withdraw this amendment, as it is now mute, given the amendment Councilmember McDuffie and I were able to move and pass. So on to Amendment 2. Chairman, at this time, I would like to move Amendment 2 that I circulated. Colleagues, you know, our residents are scared. Frankly, so are we. We are charged with passing laws that are supposed to keep them safe. And right now, most people don't feel safe. We are here today to try to pass a bill that is supposed to put us on a better path. My amendment to simply implement a record sealing law faster does nothing to endanger our residents or our families. In fact, it creates a much better path for residents who desperately need our help. 2 years ago, the council passed the Second Chance Act, a compromise bill that expands the types of criminal records that are eligible for sealing or expungement. That's already the law. All my amendment does is allow the district government to implement the bill in the next fiscal year rather than waiting until 2027. That's it. Record sealing is a crucial component of public safety, but DC has one of the most complex and restrictive record relief laws in the country. This impacts people's ability to access opportunities, to secure jobs, to find housing, and to rehabilitate back into our communities long after they have served their sentence. 1 in 7 adults in DC has a publicly available criminal record, and only half of those records include an actual conviction. This amendment will not change the content of the Second Chance Act in any way, but it will bring much needed relief to DC residents on a faster timeline. People would be able to file motions with the court to clean up their records starting October 1 of this year, as opposed to 3 years from now in 2027. The process for sealing records by motion is already in place, and neither the court nor MPD would have to change the way they handle the motions and subsequent sealings. The automatic parts of the law requiring the court and agencies to create automatic record sealing and expungement process will require time and funding to prepare to implement. So those parts of the law would not go into effect until fiscal year 2028. The Secure DC legislation leans heavily on policing and prosecution and on punishment to address crime in DC. Those are all things that we must address. But if we truly want to address public safety comprehensively, let's act with the same urgency to open doors of opportunities for people who serve their time and want to do right by our community. Earlier today, we voted to confirm a returning citizen, Mr. Caston, to a position of leadership in our city. I'm confident Mr. Caston and others like him have many things to offer our community. Allowing people the chance to seal their records will help us create more leaders like him. We call DC a city of second chances, but thousands of DC residents who truly need a second chance aren't getting it right now. For thousands of DC residents whose access to jobs and housing are defined by their past offenses. We can help change that today. I ask my colleagues to support this amendment. Thank you.
Thank you, Councilmember Lewis George. Councilmember Pinto?
Thank you so much, Councilmember Lewis George. So I support record sealing, and I think that there have been a lot of great steps that this council has taken in previous years to change the law around both record sealing and expungement. I'm worried about something that you said that I've heard from a couple of our colleagues, which is that we're moving this big omnibus today. So kind of why not this additional piece? There are a lot of great, important ideas for public safety that are important. This bill is not a tack on of everything contemplated. This is a bill that every piece had a hearing, that we went through a very deliberative process. There are questions that I have that I ask for every single provision of this bill. For example, what is the cost? How is it going to be implemented? Do the courts have the capacity to implement this in an earlier year than initially expected? Have we resolved the concerns about automatic expungement versus record sealing and applications? Do we have the right breakdown of which crimes are eligible for which? And so I think that what I would prefer to do is work with you between now and the budget and see if this is something that we can fund in the budget, if it's just an applicability date issue, as opposed to include it in a different piece of legislation that did not address and touch these issues. As you know, we have significant vacancies in our courts right now. And we don't have information about the FIS. We heard back from the FIS that there was insufficient time to determine if moving up the time frame will present additional costs to MPD. Every single decision we made in Secure DC had very consequential impacts on the FIS, and it's a balancing act. And so I ask that we continue working on this important provision that I agree with, that I support, but this is not the place to do it.
Further on the amendment,
Chairman.
Councilmember Tran White?
Yes, I want to thank you, Councilmember Lewis George, for this. I think that this is the time. I think there are a lot of provisions in this bill that's heavily law enforcement. And it has to strike a well-balanced approach. And I've introduced a bill 25-655, similar to this, and we as legislators would like to create a balance when we present stuff to the public. And so today I'm going to be supporting this measure because there are provisions in the bill that enhance penalties that target people. That's some good, some bad. But this gives a balance to, if we're talking about Secure DC, like you said, those individuals who come home deserve a chance to have whole lives. And so the bill I introduced that haven't got mocked up yet, we're hoping to get that. Councilmember Pinto, was 8 organizations, 152 people, in which we had 4 Zoom meetings about that. And I think it's time for the council to look back at those codes and get them up to date, because people are coming home and want a chance to get a job, want a chance to get equity in housing, and they're simply facing too many barriers to be returned to citizens after they've already done their time in the prison system. So I look forward to supporting this today. Thank you.
Councilmember Fruman.
Thank you very much, Chairman Mendelson. I'm trying to understand the practicalities here because there is no FIS. And so if we pass this and the mayor doesn't fund it, then we need to revisit it in the budget in any case, and could shape it in the budget, I would think, if we were doing it. So there is, if it was a thing that the administration embraced, then we could achieve it. And if it was a thing that the administration didn't embrace, we could be back in that place where you're working on it in the budget process. Am I understanding it correctly?
I think that's fair, but I would say that it's important important that the administration embrace this package so that we can get it funded and implemented. We have to be strategic and realistic about what is actually going to be funded and implemented. And I think not thinking about it in those terms is going to set our goals backwards as a council, because there are other ways we can accomplish those goals, and tacking things on to a bill that didn't contemplate those issues is not the appropriate way to do it. Otherwise, we could do that with dozens of other topics here.
But in the meantime, if this does not pass, you are making a pledge that you would work together to try to figure out how to do it in the budget?
Yes, I support record sealing. I think that the budget is the appropriate place to work on it. And I ask my colleagues not to oppose the idea of this, but to trust my judgment on this in accomplishing what we're actually trying to accomplish with Secure DC, in working so closely with all of these provisions and the very complicated matrix of making sure that our implementing partners are actually going to do what we want them to do.
Thank you very much.
Thank you, Councilmember Fruman. Further on the amendment, Councilmember Lewis George, does that mean you want to be recognized again, second round?
Correct. Just quickly. I just want to say, I think this is what we're accomplishing, trying to accomplish. I think when we hear remarks, people are going to say along the same lines, we're trying to make our city safer. People who can't get a job are more likely to look for other ways to make money. Not all of them will be legal. People who can't get housing are unsafe on the streets. And so in this same legislation, we are, especially around pretrial, going to be, incarcerating more people for more different crimes. So we're going to be increasing the amount of returning citizens we have. And so I think as we talk about striking a balance here and about the overall goal of this legislation, which is for us to have a safer city, we're doing that. This is already law. It's deemed funded. So we move up a date, it becomes applicable, in our position. And so, and with every legislation, including this one, we'll have to find, we'll go through the budget process. But I think if we're talking about what Secure DC is and sort of all of the things people are saying we want to do and to balance it out, this is a direct way to do that. And this bill went through the full legislative process over several council periods. And it is, and I think we should move forward on it. So I would ask my colleagues' support, and I would ask for a roll call vote.
If there's no, there is further. Councilmember Robert White.
Thank you, Chairman. I'll keep it brief at this point. I just want to remind us that this is post sentencing, post people having served their time. This is about helping people reintegrate, which I think ultimately makes us safer. And so there will be things we have to take up in the budget to make sure this becomes real to the concern of members. And I think it's a legitimate concern. Passing the bill doesn't make it real. Being able to process these does. And when we think about what makes us safer as a city, people being able to work, to apply for housing, those are the things that are going to help us stabilize. So I think this is a good provision. I think it speaks to exactly what we're trying to do here, make the city safer. But to some of the concerns raised earlier, I do think they are right. We have to make sure this becomes a focus in the budget as well. Thank you, Chairman.
Thank you, Councilmember. This would be second round for you. If there's no one else, Councilmember Pinto.
I'm going to say something that's going to not have a great reaction by my colleagues. Last year, when we tried to reform the criminal code, we were reminded that we are not in the legislating business alone because we are not a state. So I need everybody to remember that we have some friends and opponents a couple blocks away who are very interested in getting involved in district affairs. And so it is not a theory or a out there concern when I say that there is strategy behind every provision in here to protect district interests, not just for this bill, to protect home rule. Okay? We have very, very real threats when it comes to home rule and people wanting to take away our local government. So it's not just up to us with all of the policy preferences that we want to make. This is what I'm talking about when I say it's a complicated matrix that we're dealing with. And I worry deeply about us being short-sighted and thinking that it is just the 13 of us and making these decisions, when the reality is a lot is at risk for all of our district residents.
Council, you know, I'm going to ask again for order in the chamber. Let me be clear. I think there's, without exception, everyone in this room is concerned about public safety and justice means fairness and equality and that the system treats everyone correctly. There still are differences of opinion on how to approach that, but really we should be respectful that the intent is the same, even if one disagrees with the particular substance. Let's just be respectful of that, please. It's a bit hard for us to have our discussion when there's a lot of, I'll put it nicely, noise in the chamber. Councilmember Robert White.
Thank you, Chairman. We won't up here always agree on every issue and every approach. But I do want us to be grounded in reality. Councilmember Pinto is correct. Congress intervened in our public safety legislation and overturned it. And they will do it again. This issue with Congress is getting worse and not better. We do have to be strategic, because not being strategic puts us on the opposite end of where we hope to be. I come out differently on this issue than you, Councilmember Pinto, but I think that underlying notion that we have to be strategic and remember that Congress is looking for an opportunity to jump in and reverse all of our laws is real. I hope that the mayor stands with us this time, because that hurt us in this congressional issue. But we do have to be strategic, and I think all of us who want to see progress in this city, we have to remember that, because we got to play the long game. If we don't do that, it's going to hurt our folks. Thank you, Chairman.
Thank you, and I'll take a little prerogative here. So the House Committee on Oversight and Accountability is meeting today. I think the vote is this afternoon to overturn part of our police accountability bill from last year. All of the members, 12 of the members signed a letter yesterday urging them not to, on the basis that this has to do with provisions that allow bad cops to remain on the force. Give me just a second. What do you call them, dirty cops? Congressman Raskin referred to them as dirty cops in arguing against the bill. The vote is this afternoon, but it does reinforce what you just said, Councilmember White, that we have to be mindful of what's going on with the Hill as well. Was there anyone else who wanted to speak on this? Councilmember Fruman,
Thank you very much, Chairman
your
Mendelson.
second round.
I just do want to say, I mean, we started in this morning in the breakfast and here in the hearing, I think all of us have gone out of our way to say, to acknowledge the remarkable work that you have done, Chairperson Pinto. And you pulled together an enormous amount of material. There's lots of things, there are things in the ultimate product that folks in this room deeply oppose, but there's also a lot of things that were in some of those other bills that folks in this room would be really glad that they're gone. And so this is a very tricky terrain that you have navigated, I think, masterfully. And so where I am is when you say this is my judgment about the way to do it, I think you're way closer to it than I and all the different pieces that have been moving around. And so I am prepared to defer to your judgment on this. And I think even as folks disagree, I hope we all share that admiration for the work that you've done. So thank you.
Is there any further on this? We have this amendment before us.
Yes, Chairman, I'm asking for a roll call vote.
This is Louis George's amendment number 2. Madam Secretary, would you call the roll?
Councilmember Trayon White,
Yes.
Councilmember Trayon White votes yes. Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Freeman,
No.
Councilmember Freeman votes no. Councilmember Gray,
Yes.
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson,
No.
Chairman Mendelson votes no. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Parker,
Yes.
Councilmember Parker votes yes. Councilmember Pinto,
No.
Councilmember Pinto votes no. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. Mr. Chairman, there are 10 yeses and 3 nos.
The amendment is approved. Further, Councilmember Lewis George?
Thank you, Chairman. At this time, I would like to move Amendment 3 that I circulated. This amendment would maintain the threshold for first-degree theft that is currently in the law at $1,000. It would also make $1,000 the threshold for the cumulative value of multiple deaths within the 6 months. I want to note that even during my January 18th Ward 4 Strategic Safety meeting, Chief Smith stated that MPD had requested that the cumulative threshold for theft be set to 1,000. So this amendment is actually in line with MPD's request. Second, Pew conducted an analysis of 37 states that have actually increased the value of a theft that would trigger felony charge. Pew found that changes to felony theft thresholds had no impact on property crime or larceny rates. As the report states, the amount of a state's felony theft threshold, whether it is $500, $1,000, $2,000 or more, is not correlated with its property crime and larceny rates. Third, lowering the felony theft threshold would also put DC way out of step with other jurisdictions. Only 3 states have felony theft thresholds of $500 or less. The threshold for most states is currently between $1,000 and $1,500, but some, including Texas, have a threshold as high as $2,500. The trend nationwide has been to raise the threshold, not to lower it. Not only would lowering the threshold not lower crime rates and leave us moving in the opposite direction as other states, but it would leave significantly more people with a felony criminal record. In 2022, there were 856 incidents reported by MPD in 2022 involving theft of $500 to $999. A lower threshold would make hundreds of more DC residents liable for felony prosecution under the lower threshold. Every theft is bad, plain and simple. No one likes that at all. But if an 18-year-old student takes another student's phone from their backpack, should they be saddled with a felony record that will make it hard for them to obtain housing, employment, and higher education? So they should be facing the possibility of 10 years in prison. That would be the real life impact of lowering the felony threshold to $500. Retail theft is a problem in the district, and there are effective ways to address it, from strategic enforcement from MPD that has already begun to investing in cracking down on coordinated retail theft rings. But making this low-level, non-violent offense a felony with one of the lowest thresholds in the nation and subjecting hundreds of more Black DC residents to lengthy prison sentences makes little sense, especially given that we know the provisions like these fail to reduce retail theft. So I ask my colleagues to support this amendment for those following reasons. Thank you.
Thank you, Councilmember Lewis George. Councilmember Pinto.
Thank you, Chairman, and thank you, Councilmember Lewis George. So we have also looked at a number of other states, namely California, which used to have felony theft threshold at $495. They raised it to $950 and saw a dramatic increase in retail theft. Similarly, in the district, we have raised our threshold to $1,000 and have seen a dramatic increase in theft. We hear every single day about retail theft, about people's bikes being stolen, items that are just under $1,000 that there is effectively zero consequence for. So yes, you can pull out the maximum allowable penalty for a felony theft. In practice, that's not what's happening. We are seeing cases over and over and over again where MPD is perhaps making an arrest, booking somebody, and there is either a charge or no charge, and sometimes the charge leads to literally zero consequence or an entire probation period. This is leading in practice to people saying to the police, what are you going to do about it? And I quote, and I hear this all the time, following thefts. And so again, we are not starting our society over in a vacuum. We are responding to the trends that we're seeing right now, which are victims being left without recourse when items are being stolen from them, from their person, when our businesses are having their shelves cleared out, and closing up shop and leaving the district. This is a very real challenge that we have to respond to. We have an obligation to respond to it and make sure that our police and prosecutors have sufficient tools to bring these cases and to address the retail theft. I know I am not alone. I know all of you are hearing from residents every single day about this. Like all provisions, this is not going to solve all theft overnight, but it is an important tool to lower the threshold to $500 to make sure that we have some basis to pursue these cases. And so I ask my colleagues to oppose this amendment and to keep us on track to what we need to do today, which is turn the district on a safer course. And this is one way that we have to do it, and that's an important part of Secure DC.
Thank you, Councilmember. On this amendment, Councilmember Fruman.
Thank you, Chairman Mendelson. Councilmember Pinto, one of the things that Councilmember Louis George raised was the idea that MPD had asked for 1,000. And what is MPD saying about the change from 1,000 to 500? What's your response to that argument that Councilmember Louis George offered?
Well, before this law, the cumulative impact was not being met. So I assume that that's what MPD was referring to in their conversation with Councilmember Louis George, to make sure that when there are repeat offenses, if somebody is stealing $200 worth of items or merchandise multiple times within a month, that needs to be able to be aggregated. But MPD is fully supportive of the $500 threshold, as is the U.S. Attorney. And they both believe that it's going to help bring these cases down and give their officers the tools they need to actually pursue them. And so they're fully behind this change.
Further on the amendment? I'm going to pause for just a second. Councilmember McDuffie, did you have a question?
I do. I raised this question during the breakfast, and I love for Councilmember Pinto to speak to this. A little while ago, I started a retail crime working group with a number of retailers across the District of Columbia, both large and small, based on some of the things that I'm sure folks have seen play out in the television media, the social media, and other places around retail theft. And I'll be quite candid. I have my own personal experiences where I have observed how brazen individuals are with theft in the District of Columbia. I won't name the stores, but there have been multiple instances where one I'll share, I was in line paying for an item and watched a security guard struggle, female security guard, with a guy who wasn't stealing food, he wasn't stealing Pampers, he wasn't stealing water. He's trying to steal a bike, a whole bike. And he left after he lost the struggle. Then he came back and tried to steal the bike again. And this security guard was actually armed. I'm just trying to illustrate the challenges that I think retailers are facing. We've seen stores close for multiple reasons. I don't think in every instance it is specific to crime, but I think in a lot of instances, crime is the issue that they're challenged by right now. I know the threshold used to be 500. I know when it was increased to 1,000. But I'm curious as to whether or not your conversations with the Metropolitan Police Department suggest that they are going to take matters in these instances more seriously in working with retailers to address this issue. I have heard, and I'm not trying to imply that they don't, or all officers, let me be clear. There are some instances that I've heard, and I've seen videos where crimes have occurred, retailers have reported it, and then officers responded without doing anything. So they're using their discretion to determine when they should pursue these crimes. And I think that has an impact on what we're seeing right now. And I'm curious as to whether or not your experience is that MPD is saying they're going to be working with retailers or doing something differently than what's going on right now in terms of how to solve for this issue that retailers are experiencing.
Yes, thank you for that. And I think you're right. It's a little bit of all of it. And the truth is that it is already a crime to steal, and we need those cases to be taken seriously. What I'm talking about with the practical effects is that we're seeing, even in the event that an arrest is made, and even in the event that a charging decision is made and the U.S. attorney is moving forward, there is so often no consequence tied to that successful prosecution that it's creating a cycle of apathy of officers to intervene in these cases. And so I have had dozens of conversations with the police chief, with our commanders, with rank and file officers, with the U.S. Attorney's Office, line attorneys, and the U.S. Attorney, Deputy Mayor for Planning and Economic Development, Deputy Mayor for Planning, Public Safety and Justice, Mayor Bowser, about sending a very clear message that once we pass this, everybody knows what the threshold is, and theft in the District of Columbia is no longer acceptable. And that's an important piece of this in my conversations and work on this.
I appreciate that. And I want to make sure we get this right because, the consequences that we're seeing in terms of some of these closures, the impact it is having on some of these communities where, seniors can't, get to the pharmacy to get their medications, where, the limited healthy food options that exist in some of these places will no longer exist when these places close. We've all heard the threats with certain grocery stores. We've seen beyond threats of leaving where actual closures with CVS and other places. I want to make sure we get this provision right. And I appreciate Councilman Lewis George in moving this, but I would love to work with you on this to make sure we strike the right balance on this, because I completely identify with the concerns you have raised, but I also identify with the concerns that Councilmember Pinto has raised. And so I'd love to get a little bit more comfortable with this amendment. If you could work with me on this, maybe Councilmember Lewis George, and withdraw it until second reading.
As long as we're gonna get it done for second reading.
I appreciate it.
So that means you're going to withdraw it and you're going to come back on second reading and hopefully things will get worked out.
Yes, Chairman.
I have another amendment. Mr.
Thank
Chairman.
you. Yeah, I know, but Councilmember Tran White is next and then you. Councilmember Tran White?
Thank you, Chairman. While we're in a season where we know that crime has historically risen in the district, I've been tooting this horn for quite some time. And I believe that we don't address the problem, we can't get to a solution. And for at least 9 or 10 years, the narrative that crime was down, or crime was historically going up. And so I think we have to create what I call a comprehensive approach to addressing crime. And I think that our role is one of many roles in doing just that. This bill speaks to a number of measures that some are good, some are bad, and some we just don't know yet until it happens. What I do want to overemphasize in this First Amendment is the ability to address wraparound services in these drug-free zones, because just arresting or enhancing arresting powers will be particularly cumbersome and maybe unconstitutional, especially for brown and black people in the district. Let's just say what it is. This particular measurement, and I'll read it, the drug-free zone means public space or public property in an area not to exceed a square 1,000 feet of each side that is established pursuant to Section 3, in which the district government has previously targeted for intervention by providing added outreach and information to government, to individuals in an area that needs employment, skill trainings offered. Also, Department of Employment Services giving information and job opportunities, mental health services, behavioral health services, and addiction treatment services offered to the residents by the district agencies, and information regarding district homelessness and housing assistance. This is real reform, and this makes DC more secure. And I think that we've started some of that. I want to give some kudos to Brooke Pinto because she named some of the things we were thinking about, especially around our nonprofit communities, actually focusing and getting grants for these communities. I live in these communities each and every day and been here for 39 years, and we have not done enough to address the underlying social ills affecting our people in the district. But I see we're coming back. And again, this legislation is heavily law enforcement, heavy from, you can just look at it and tell. But I'm trying to invoke a balance and make sure we are utilizing not just the Metropolitan Police Department, but also our other government agencies to target, I don't even want to use the word target, to provide resources to these areas as well. And I look forward to your support on this, and I have other measures, Chairman.
Before I recognize Councilmember Pinto, Councilmember White, you or your staff circulated an amendment.
This one was at 12:28, I'm sorry.
Well, I have one that's circulated 1:15 and one that was circulated 8:37.
So this particular one I'm on now is at 12:28.
So the one that's circulated 1:15 doesn't count,
Let me check real quick.
because it says, please see updated amendment memo removes the same
I stand corrected, Chairman. Yeah, that's the correct one.
as the one at 1:15.
Let me check my email real quick.
One of these days we'll get back to circulating paper on the dais,
Yeah.
Madam Secretary. I saw somebody
I don't
nodding
have it
their
at
head.
1:15. Oh, I don't.
Do we have a larger dais so we could fit the laptops up here and get a printer for?
Yeah.
Yeah, but I'm here. I can't go to the back.
No, Chairman, you're speaking to another amendment. You're speaking to the amendment that will require a police officer to reasonably establish that a crime has been committed. That's not this, Chairman.
No, the amendment that was circulated at 1:15 as a mandatory section 5B in section 38 of the bill is amended to read as follows. In making a determination that a person is congregating in a drug-free zone for the purpose of committing an offense, et cetera, et cetera.
It's not this bill, Chairman. Sir. Did you find it, Chairman?
I'm a paper person. So I have an amendment that was circulated at 1:15 and an amendment that was circulated at 8:37. You're saying the 8:37 doesn't count?
I'm not on that amendment right now.
Councilmember Pinto, do you have the correct amendment?
All right, so let me table this amendment and go to the next amendment if that works for you, Chairman.
All right, I don't have any other amendments from you.
It should be in your email.
Together with the email that circulated them.
Which is pretty normal, Chairman. We don't circulate paper like that anymore, which we should since we're back in. We do? We don't.
Well, paper always helps, but I understand that some folks are stuck in the next century and they prefer not having paper.
I have 456 emails
But-
since we started today. Can you say what time the email came around?
The challenge here is that there've been, these all came in today. Not that that's out of order. But they came in today. They're not linked on the agenda. That makes it harder for members. And then there are multiple versions that have circulated. So.
I'm happy to. Any other one?
No, hold on a second.
Chairman, let me move to the next amendment. Yeah, if we can get paper copies, it'd help. Because we, issue is the timing of the amendment being sent.
What's?
Mr. Chairman. Mr. Chairman.
If members don't object, and Councilmember White, if you don't object, Councilmember McDuffie says he has one more amendment, which also wasn't circulated, but he says it's oral. Why don't we do that and then come back to you? And in the meantime, Councilmember White, if we can all sort out what it is exactly that we have from you.
Thank you.
Councilmember McDuffie?
Thank you. Thank you, Mr. Chairman. I have an oral amendment that concerns section 19 with regard to pretrial detention. And this amendment would amend section 19 by adding a clause to subsection C that simply says the provision expires 225 days after the implementation date of this bill. Section 29 is amended by adding a subsection that states that the Criminal Justice Coordinating Council shall submit a report to the mayor and council on the efficacy of the pretrial detention provisions in this act no later than 180 days after the implementation of the bill. And section 31 is amended by adding a clause that adds the provision expires 225 days to subsections F, G, and H. Let me just briefly mention the rationale, and I think it might clarify any questions that folks have based on what I just stated. The pretrial detention provisions of this bill make permanent what the council previously did last summer with regard to pretrial detention. I supported that measure last summer, as did, I think, all of my colleagues, or at least most of the colleagues. I would like to get to a point where I can support it today, and I think this would get me there if we had some data that we can analyze to ensure the efficacy of this pretrial detention law. This does not stop the pretrial detention that is currently going on based on the emergency and temporary measures that we approved last summer. What it would do is extend it an additional 225 days for a total of 550 days, but require that the Criminal Justice Coordinating Council collect data and analyze that data and submit a report before the provision expires so that we could be armed with the information that I think we want in order to make this policy permanent. I am uncomfortable making this policy permanent without having that information. I think, as most people who I work with on the dais with respect to these types of laws want the laws to be evidence-based and data-driven. And I think this amendment makes for better policy before we make this provision permanent. To be clear, I supported it then, I would support it now. I want to put this clause in that allows us to get the data before we make it permanent. And I'd ask, hopefully, that Councilmember Pinto and my colleagues would support this amendment.
So members don't have this. However, Councilmember McDuffie provided a copy to me and to General Counsel, and I've shared it with Councilmember Pinto. To be clear, what this does is in section 19, it adds a time limit. In section 29, it has a time limit. Section 31, it has a time limit. And what you read, Councilmember McDuffie said, like 225 days after the implementation date, that should say effective date of the bill.
Yes.
And similarly with 29, section 29, where it says implementation, it should say effective.
Yes.
Those are the only two places where you use the word.
I don't know if Councilman Morales just asked me a good question. I don't know if you want to ask it on the record.
Yeah.
Okay.
I'm gonna ask, maybe because I'm getting a little punchy, is there a reason why we can't do this on second reading? The goal here is that you want to have a time limit to the changes to the law regarding pretrial detention. We could vote on that time limit at second reading, or we could do it today. Members, I'm feeling a little punchy. Maybe nobody else is. Maybe everybody else is feeling bright and fresh. Nobody has a copy of this except me, you, and General Counsel and Councilmember Pinto. Seems to me like this would be a good thing for second reading.
I appreciate that, Chairman, but I think the oral amendment is in order, and it's okay. I'd love to hear what Councilman Allen has to say on this matter.
Before you decide to wait until second reading.
Yes.
Councilmember Allen?
Wow, that's no pressure at all. I actually had a clarifying question, I hope. You spoke about the changes we made previously, this council supported in the summer, which made changes to our pretrial policies. And then we have this legislation. I think having a study of efficacy is a very wise thing to do, no matter where all of this shakes out. I know when I spoke previously with pretrial services, they talked about to be able to really evaluate, you would need months worth of data and experience. Is your intent this amendment would speak to beginning to evaluate that as of last July, when we made several changes to our pretrial detention policies, or from the effective date of this act, obviously when it passes?
I think it's a great question. It would be the effective date of when it was passed last July. So cumulatively, you have the effective date plus the 225 days that we're putting in this. That gives us somewhere around a year and a half worth of data to analyze before we make this permanent.
Thank you very much. Appreciate that clarification.
Mr. Chairman.
Councilmember Pinto.
Councilmember McDuffie, what would you propose happens after day 225? Should everybody be released if we don't extend this?
Now, Councilmember Pinto, I would hope you know that's not my intent. It wasn't my intent when I talked to you last night. It's not my intent right now. My intention is to do what is in the best interest of District of Columbia residents and to keep people safe. But to understand that the policies we are implementing actually do that. And I think this, and I'm not trying to be short with you, but I think this actually arms us with the data and the evidence that we would need in order to make this permanent. So it is not my intention to have everybody be released.
I appreciate and believe you that that's not your intention, but if we are removing the ability of the presumption, then I am unclear what the law would be on all of those who've committed the most violent crimes who are being held, on what that would mean in practice, which is why I don't want to do these changes in an oral fashion with looking at the language 2 minutes before we vote on it without an opportunity to be thorough and thoughtful as we have with every other provision. But I will say some additional reasons why I don't want to do this. One, last summer, when we voted on this, the council, not only did we vote on changes to pretrial detention, we required for the first time that the Criminal Justice Coordinating Council produce a public dashboard. So all of us, all of our colleagues and everyone in the public can be on the same page about who's being arrested, who is being charged, what is the pretrial services agency doing, how effective are their conditions, are people meeting their conditions of release, are there reoffenses? all of that information is now available. So to require an additional report, I think is just an added layer of bureaucracy that's not going to help us. Some of the pieces of data that we looked at were one, a reduction in violent crime in the 30-day period following the passage of the emergency bill, which was quite notable given it was the warmest month of the summer when normally in every other year we see crime go up. We've seen judges be able to hold people who, but for the presumption, wouldn't have been able to hold them in 2 cases of homicides. We have continued to see people getting released and reoffending, even under this presumption, because it was so narrow to the most violent crimes. So I think that this body made very conscientious and thoughtful steps this summer to be narrow and focused about this. We now have 6 months worth of data that we have been tracking very closely and do so in partnership with CJCC and all of our public safety partners. And it's now time to make those changes permanent so we can continue to track it moving forward and give some consistency and, again, some hope to victims who are continuing to be left out of this conversation, to know that if they are harmed with the most violent offenses, that the perpetrator is not going to be back in their community the next day. I think it is a fair balance. It's a narrow balance, and I oppose this amendment.
Mr. Chairman.
Second round, Mr. McDuffie. Second
simple-
round,
this-
where's the clock? Please.
I think the simplest way to put this is to say that, and I think I have a record that demonstrates I care about victims. I care about justice. And I think what I'm putting forth in this amendment demonstrates that this council, if supported, cares about those things deeply. It wouldn't change. This amendment does not change what we're already doing. What it says is we're going to be armed with additional information about the impact of what we're doing before we make it permanent. That's all it does. All right? We started this back in July. You said we have 6 months of data. If we do and somebody's analyzed it, I love to see the results of it. I know that we have dashboards. I think that's a good thing. I think it's positive. I don't think this takes away from what you intend to do in your measure. All I'm trying to do is say that upon the expiration of this amendment, we will be armed with additional information to inform whether or not this should be made permanent. That's all it says. And it also ensures that the report the CJCC would do around this information, the data that they collect, would get to us before the expiration in order for us to make the determination about whether to make this permanent. We did this in the context of the summer months where, again, we're experiencing a crime crisis. We got a culture of gun violence in the city. We need to do a lot more to combat it. I'll talk more about that when we get to the underlying measure, but I think this is a very reasonable amendment that allows us to continue to do what we did in July, except we will be armed with more information so that we're making an evidence-based, data-driven decision, which we are not making today if we improve this.
Members' time has expired. Councilmember Fruman.
So I do have some sympathy with the idea of sunsetting things and having the opportunity to look back, to have a presumption of it going away unless it's proven itself to be effective. So I'm sympathetic to the amendment Councilmember McDuffie is coming forward with. I am curious, 225 days from the effective date, what's the anticipated effective date of this bill? How does this mechanically work? Why is it 225 days? How does that fit in terms of our legislative calendar? How does it fit in terms of the summer months, which are such a challenge, and being able to evaluate the data from the summer months? I'm not opposed in principle to what's being talked about, but I do think that taking the time between now and second reading to figure out all of the details makes sense. but help me understand the calendar of 225 days, when that starts, when that ends, how those mechanics work.
So right now, and I'm, general counsel should be correct me if this somehow doesn't sound accurate. The omnibus that we ultimately pass will go into effect. It will have an effective law date at some point. The provision that we're speaking, not yet. The provision, and maybe somebody can guesstimate what the effective law date will be if it's passed today, the omnibus. Well, actually, we still have second reading, so it will be after we pass it. There's an effective law date, and then there's 25 days after that date. I'm sorry, 225 days after that.
So if we have a second reading in 28 days and 4 weeks, then that takes us into March, and then you're going 200, then the mayor signs it. So
It's like every other bill we have that passed on a permanent basis, there's an effective date of the bill.
right, I'm trying to figure out when that's likely to be.
Well, I guess, but let me try to make sure I'm understanding the heart of your question, because ultimately though, nothing changes, right? So you're calculating the days, but we're continuing to do this.
No, well, I mean, what I'm trying to understand is 225 days after an effective date, or 190 days before an effective date, we would be thinking about, do we maintain it?
Yes.
So I'm trying to understand
Yeah.
how that
Okay.
calendar works.
Right.
That's what I'm trying to
So
get.
the point of the amendment around section 29 that speaks to the CJCC's report, 180 days after the effective date of the bill gives us the lag that we would need, right? 180 days after the effective date, we would have the CJCC report that analyzes all this, which is before the expiration of this provision.
But I mean, I thought you were saying
Somebody's time
180
has expired. We are struggling here with this amendment, partly because it's an oral amendment. partly
Motion to
because-
end debate.
What's that? Well, I'm going to ask again that this be withdrawn and that we consider it on second reading, or otherwise I would join with the chair of the committee and ask the members not approve this.
Mr. Chairman, there is a motion on the floor.
What's the motion?
To end debate.
All right, I think it was made while I was speaking, so that was not in order. Mr. McDuffie, are you going to keep the Councilman McDuffie, I've asked you a question.
Chairman Anderson, I didn't hear your question.
My question was, are you willing to withdraw this and hold off for second reading?
I would love to have us vote on this measure right now, Chairman, and I would ask for a roll call.
All right. If there's no further discussion. Well, Councilmember Henderson will be annoyed with me if I recognize you because she tried to close debate.
But I haven't spoken yet on the amendment, so.
All right, I hope folks are feeling that this is getting a little disorganized here. So Councilmember Allen, and then we'll have a vote.
I'll try to have very well organized thoughts, Mr. Chair. I think it's important that we recognize that laws and legislation don't have a finish line. We always make changes, we always amend, we always have new information that comes in, and that's how we edit, we change, we try to evaluate. The spirit of this amendment, I think, aligns with that, which is to be able to measure the effectiveness, what works and what doesn't. And I would hope that as a legislative body, we're very willing, as I think we are with the measure we're about to pass in a little bit, we're going to make changes based on what we're hearing, what we're seeing, and how that works. From the standpoint of a rough calculation of when this would pass second reading, when it would be signed, when it would be transmitted to Congress, when it would go through its review, we're talking about December of this year, maybe January of 2025. So that gives a long amount of time to be able to both let CJCC through pretrial services and their partners be able to get back with an evaluation. And I believe that this council will continue to make this a priority. And I know the chair of the committee will continue to push and make things a priority. So I think that the amendment, whether it's today or whether it's a second reading, I think has merit to allow us to take evidence-based approaches to say what works and what doesn't. We're passing an expanded pretrial detention today. So having the ability to evaluate it, I think is a good thing. So thank you, Mr. Chairman.
Madam Secretary, would you call the roll? The vote is on, Mr. McDuffie actually probably needs to be restated because it's oral. The amendment is to amend section 19 by adding a clause, a new subsection C that adds, this is not actually legislative language, that adds that the provision expires 225 days after the effective date of this bill.
Mr. Chairman, may I just ask one more time that Councilor McDuffie consider withdrawing this amendment, not putting our colleagues in this position, working together with us between first and second reading. We've been working on these provisions for months and months for a reason. We've required CJCC publish data for a reason, and duplicating those efforts with an additional report without more context and giving us a chance to work together, I think is premature, and I think puts our colleagues in an uncomfortable position. So I ask you again to withdraw this for now so we can try to work together between first and second reading.
The amendment also amends section 29 by adding a subsection that states that CJCC shall submit a report to the mayor and council on the efficacy of the pretrial detention provisions in this act no later than 180 days after the effective date of this bill. And again, this is not legislative language. Is this good enough for you, Madam General Counsel? And section 31 is amended by adding a clause that adds a sunset clause of 225 days to subsections F, G, and H. I'm not sure whether that's 225 days after the effective date or what. So that is before us. Madam Secretary, would you call the roll?
Councilmember Allen,
Yes.
Councilmember Allen votes yes. Councilmember Bonds,
Yes.
Councilmember Bonds votes yes. Councilmember Fruman,
Present.
Councilmember Fruman will be recorded as present. Councilmember Gray,
Yes.
Councilmember Gray votes yes. Councilmember Henderson,
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George,
Yes.
Councilmember Lewis George votes yes. Councilmember McDuffie,
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson,
No.
Chairman Mendelson votes no. Councilmember Nadeau,
Yes.
Councilmember Nadeau votes yes. Councilmember Parker,
Yes.
Councilmember Parker votes yes. Councilmember Pinto,
No.
Councilmember Pinto votes no. Councilmember Robert White,
Yes.
Councilmember Robert White votes yes. And Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Mr. Chairman, there are 10 yeses, 2 nos, and 1 present.
The amendment is approved. Councilmember Trayon White.
Thank you, Chairman. I'm gonna drop down to amendment number 2. Which addresses section 26. And this speaks in reference to wearing of masks. So I do want to get some clarity on this. There was some misinformation about this, and I believe that my colleague did not intend to discriminate in any way against anybody of any faith. And so for clarity, I do support one of the amendments to this by Councilmember Christina Henderson, but this amendment adds the word ski mask to the language to be specific. That's the only amendment I have to this particular part. Number 2 is to add the word ski mask to this amendment. and this was circulated at 2:48 PM. And I want to speak to the bill, I amended that section because as we know, we see and hear and feel and experience, a lot of, crimes in the district. We want to ensure that we don't mistarget people regardless of what they have on their faces. But if this is to pass, I want to make sure that we are protecting individuals. I was concerned in this bill about the section that said, in fear of life. And that, it says intimidated, threatened, or abused or harassed by any other persons or cause any person to fear for his personal safety. And I do want to say that, focusing on ski masks specifically is not unique with the district. Other states like California, Connecticut, Delaware, Florida, Massachusetts, Michigan, New Mexico, North Carolina, North Dakota, and Ohio, focus on that. And there's a notion in this bill that talks about demonstrations. And I don't want, we are in a diverse city. Well, people come from all over to protest here. And I don't want Muslim women in demonstrations to feel attacked or abused at all. And I know that's not my colleagues' intention at all. And so I wanted to give clarity with that by adding this provision. And I'm asking that this amendment be accepted, Chairman.
We have the amendment before us. Councilmember White, you said that the only thing this amendment does is to add the word ski mask.
Yep, add the word ski to the word mask.
Mr. Chairman, can I ask a question?
Yes.
Okay, I just want to be clear, Councilmember White, because I hear you that the majority of, or we're seeing a lot of crimes committed in ski masks, but then the language, as you know, goes on to say, or other article whereby a substantial portion of the face is hidden, concealed, or covered as to conceal the identity of the wearer or enter upon or be within public property. So one of the other things we're seeing is bandanas covering an entire face, or another garment kind of being wrapped around someone's face in furtherance of a crime. So I just want to make sure I'm clear on your intention here with adding the word ski, but keeping in the or language.
Thank you. I do agree with that. Historically, prior to the pandemic, there were other crimes committed with other forms of face coverings that kept people from seeing on camera who the perpetrators were. And so we thought not to take some of those out, but we specifically wanted to focus on the ski mask provision. That's unanimous in a lot of these crimes, especially robberies, shootings, that this bill attempted to address, but didn't specify what. So we wanted to clarify that without eliminating the other types of mask coverings. So we added the revision to add the word ski.
I'm a little bit confused. The amendment says section 26, and I'm looking at the amendment nature of a substitute. And section 26, which starts on page 52, which is line 1596, concerns the Taxi Cab Drivers Protection Act. Further, this amendment, instead of just saying add the word ski, I guess rewrites the whole section. And so I don't know whether in fact that's the only change. And that's not to, but how do I put this? It's not to throw shade, but when the entire text is reprinted is that really the only change? I don't know. And I start with trying to find in the amendment nature of a substitute, and I can't find the section offhand.
Councilman Pinto, do you agree with that? So maybe we had, there's been so many revisions to this bill. Let me do this, Chairman, for the strength of clarity. Let me, section 4.
Page 57.
Section 4, page 57. We still gotta get it right.
Can I speak to this briefly, just on the language piece? So this version of the amendment puts back in the language that we voted to remove from Councilmember Henderson's amendment of the intent to cause another person to fear for his or her personal safety.
So we want to amend that so that can be accepted, because when you introduce bills at the same time, you don't necessarily.
Right.
Do what?
I guess I'm trying to just think through this, which is what another thing that worries me about doing these amendments on the fly in this way is that masks were meant to encompass the broad range of what we're seeing, which are face coverings that are covering an entire mask. Yes, often ski masks, sometimes bandanas, sometimes sweatshirt wrapped around someone's head to conceal their identity. And so I worry about adding a word, even though it doesn't feel like it makes a huge difference, without understanding the consequences and looking through the cases and seeing if that would be harmful to MPD's ability to make a stop in these cases. So I'm apprehensive just to add the word ski without a fuller understanding. I also don't really know what it would do, because we're still keeping in the or language. So I'm happy to work with you between first and second reading, but I'm a little hesitant to accept this word as friendly without a fuller understanding.
But Chairman, what I'll do is, Chairman, I'll withdraw this amendment right now for the sake of bringing it up in the second reading, so we can get some clarity on this language. And it's pretty simple, really.
Okay, so the amendment is withdrawn. It is, I finally found it, by the way, it's section 25 on page 51, line 1567.
So major.
Line 1567 of the amendment nature of a substitute. I have
There's
the
several
amendment nature of
versions.
a substitute. All right, so that's it's withdrawn for the moment. Anything further, Councilmember White?
No, but I do have some concern, Chairman, in reference to, well, let me ask Councilmember Pencil this, if you may, Chairman. In the bill, in section 15, I believe you removed, you put language in it that to remove the officer's name and badge number. And until sustained allegations that pertain to the officer's commission of a crime, or the officer's interaction with a member of the public, or the receipt of a judicial officer's adverse credibility findings in the criminal proceedings is concluded in that place. And I'm just concerned that officers are sworn in officers of the District of Columbia, and we know, I mean, I've seen the articles in 2022 where we let back 37 officers who got suspended and fired back onto the police force and paid them over $500,000 that we don't know if where those officers are, if they improved their behavior. And that's just that cohort of people. I'm concerned that we are hiding the officers from the public. I think that the public has the right to know. And in most cases, these particular officers who may not have been convicted yet may take 2, 3, 5 years to go to court. And I think that I'm just trying to get your understanding of that particular revision to this bill. If you can speak to that, Chief.
Can I jump in before you answer? Because this was actually an issue that I negotiated with Councilmember Pinto. Many members know that there were a number of issues concerning police accountability that were raised as concerns of Committee of the Whole. I sat down with Councilmember Pinto, went over all of those. This was one where I raised this with her, but when I looked at the section, it does strike the phrase of it does strike the phrase about a police officer's name and badge number. However, it still requires that there has to be the notice of the hearing. These hearings, adverse action hearings, are public hearings. But until the police accountability bill that Councilmember Allen moved when he was chair of the committee, the MPD didn't notice the hearings. So these were, yes, hearings. So they were public hearings, but nobody knew about. So in the police accountability bill, it requires that there has to be notice. That continues. And there has to be a explanation of what the issues are, what the allegation of, what the issue is. That's still there. And my view in working with Councilmember Pinto was that, well, if you strike the name and badge number, it's still going to be a public notice. It's still going to tell you what it is. And the chances are is that MPD is still going to say who the officer is. Maybe not, but it's going to be a public hearing. And the facts around that hearing will be included in the notice. So the public is still aware and they still know what the allegations are. Do you want to add to that, Councilmember Pinto?
Sure. I appreciate that, Chairman, and kind of the reminder that there are a number of things in here and on balance, we sought to make the appropriate judgment calls that lead to police accountability and basic employment rights. And so when it comes to adverse action hearings, these are for allegations that have not yet been sustained, that the public has a right to watch, to participate in. They will be posted publicly. But to share an officer's name before a determination has been made that any violation has actually occurred, I don't think is the appropriate balance. I'll also just add, and I mentioned Congress earlier, Congress passed today a law repealing the entire adverse action notice process in DC, saying the public can not have access to anything. So when I talk about getting these balances right to protect our district values and move forward in a way that leads to police accountability that's also going to be sustainable, this is exactly what I'm talking about, because Congress heard that we were thinking about playing with this. They didn't think we were going to go as far as they wanted, so they struck the entire thing out. So I wish we were a state. I wish we will keep fighting for our full autonomy as we deserve. And we have to be aware of the reality that is facing us right now. And that vote was today. So we're trying to get this balance right. It's still a public process that the public has access to these hearings. But to require the name to be published before any allegation has been sustained is unworkable.
Well, I found the language here. I didn't think I had it here. So without Councilmember Crayon White's amendment, with the amendment nature of a substitute, this is what the law will be. MPD shall publish on a publicly accessible website a schedule of adverse action hearings for cases in which the proposed discipline is termination. The schedule shall include A, the date, time, and location of the hearing, and C, a summary of the alleged misconduct or charges against the subject officer. That's what the public will know. And what your amendment would do would be to say, well, and also include the name and badge number. I ended up agreeing with Councilmember Pinto that there was enough of a notice here and the hearing is public, that there's nothing lost with the committee point.
Chairman, if I may.
Yes.
Well, I'm concerned that we are, it's not normal. I mean, if someone does something on the subway and takes off running and identified as who that person is, he or she name will be on the news, in the paper, regardless if the person is found guilty or not. And so that is really not normal. And I'm trying to understand the rationale of why we are doing that. If I can get an answer to that, that'll be helpful for me.
Well, all of this information is FOIable, including the full name and badge number of any officer. And if a allegation is sustained, meaning the public hearing process moves forward, that it was a truthful allegation, then that will all be public on the public dashboard. Again, and I cannot stress this enough, changing this provision with this amendment puts the entirety of Secure DC at risk of being overturned by Congress.
So,
Anything further?
yes, I would like to work with you, Councilman Pinto, on this revision. And I have a number of other concerns, if I can address them now, Chairman. Thank you. I am also concerned about the enhanced penalty at recreation centers. And if you, and I'm not sure why do we just target recreation centers? If you can speak to that, that'd be helpful for me.
Sure. This provision came from a couple of different things. One, following the shooting and murder of Robert Cunningham at our DC Metro, we had a deeper look at what more we can do to protect Metro employees and workers. And so we looked at penalty enhancements there when an attack is made on bus driver, Metro operator, taxi cab drivers, Uber drivers, and others. At the same time, in conversations that I had with kids and with families in all 8 wards, I heard over and over again a pleading for us to do more to create more safe recreation spaces for people. I heard so many stories of kids telling me they feel unsafe at a recreation center, that they feel unsafe getting to a recreation center, and making crystal clear that these spaces are for everybody to play safely. It is crucial for our safety goals to have recreation spaces in the District of Columbia that are accessible and safe for everyone of all ages. And to engage in a crime of violence, which is what Secure DC addresses, is a penalty enhancement if you engage in a crime of violence at one of our DPR facilities. And this is really important to get the balance right, to keep all of our residents safe and to make sure these spaces are for everyone.
Thank you, and I thank you for that clarity. But one of the things I am concerned about as a young man growing up in the city, playing at recreation centers all my life, is that sports are very competitive and it has a lot of energy, and you can see it in the NBA all the time, right? And so I'm concerned that there may be teams playing basketball that may disagree and get into a fight. And because of this law, we don't know if someone may or may not get hurt. Now, I believe that no children or no person should be fighting in general, especially at a rec. But we know in practicality, kids fight, right? And kids have disagreements, they argue. But I'm cautious that this may create greater penalty on anyone because of a scuffle on a basketball court. So you can speak to that.
Sure. No, thank you for raising it. And I think it's a real concern practice. What you're describing of a scuffle on a basketball court or a shove or a push
No,
is
fight. I'm saying a fight too. Did they fight?
okay. Well, if it's the former, it would be a simple assault and it would not be subject to that. If it is a crime of violence, which are our most serious offenses, yes, it would be subject to a penalty enhancement. And I think it should be. We have to make sure that kids are protected in these spaces. This is not a sports fight or a push. These are our most serious crimes of violence.
Well,
Councilmember, it was pointed out to me, you've been 7 minutes and there's not an amendment pending.
all right, one more question, Chairman.
If there's no objection, one more question from Councilmember White.
Thank you. And I guess this is depending on someone being hurt, as we talk about crime of violence and the definition of crime of violence. It's a list of things, just aggravated assault, terrorism, assault on a police officer, dangerous weapon, intent to kill, first degree sexual abuse, second degree sexual abuse, but also bodily injury, which could escalate this as well. So just want to give clarity to the public for that.
Serious bodily.
Significant bodily injury, assault with significant bodily injury.
So significant and serious bodily injury, and we address this also in Secure DC, is usually for things as serious as being shot in the arm. So these are, again, very serious cases that we're talking about when it comes to crimes of violence.
Thank you, Councilmember. I don't believe there are any other amendments pending. We have the amendment in nature of a substitute before us. We'll vote on that, and there's still an opportunity for discussion. We will have a voice vote on the amendment nature of a substitute as amended. This is not the final vote on the bill. All those in favor of the ANS, say aye.
Roll call, Chairman.
Do we really need a roll call on the ANS? We're going to vote again on the bill. Councilmember, it's your choice.
Go ahead. I'm just making sure everyone voted is recorded properly, Chairman.
I'd ask for the ayes. Are there any nays on the amendment nature of a substitute? Hearing none, the amendment is approved unanimously. Now we have the bill as amended. Is there any further discussion? Councilmember Nadeau.
Thank you, Chairman. I've heard from many residents in Ward 1 about this legislation. Some want the council to pass the bill because they believe more tools for police and prosecutors are needed to ensure people who commit crimes are held accountable. But I've also heard from others who have grave concerns about police transparency, civil rights, and unintended consequences of the legislation. For example, how will drug-free zones create obstacles for people living with substance use disorder in getting the services they need? I hear all of these voices, and I want to acknowledge the concerns and fears around the uncertainties. We've considered many amendments today to minimize the impact on vulnerable communities and protect against unintended consequences. I am still eager to consider these at the second reading of the bill in order to address valid concerns that are being raised by members of our community. In Ward 1, I've invested in harm reduction programs and supportive services in Columbia Heights, Mount Pleasant, Lower Georgia Avenue, U Street, and Shaw. If the executive wants to designate drug-free zones throughout the city, she must also simultaneously protect the integrity of these and similar programs around the district and ensure protections for people who need health supportive services. My team and I work closely with Councilmember Christina Henderson on the language that inserted these protections, and I thank her for her leadership on that and for Councilmember Pinto for working with us. Earlier, I withdrew my amendment that would have increased minimum reward amounts for witnesses who testify in homicide cases in an effort to create more justice for victims. I'll continue to pursue this measure, including a study on the extent and effectiveness of the district's programs and policies for witness protection and assistance. The public safety ecosystem rests heavily on prevention efforts. Historically, I've made an effort to bring that to life, supporting the NEAR Act, introducing the red flag law, and securing funding early in my tenure for violence prevention programs and expanding those each year I've been in office. We established the out of school time program that provides after school and summer programming for kids. I'm hoping we're going to get to expand that soon. And keeping our young people engaged is one of the primary tools for reducing youth crime. That's a fact. All of these and many other initiatives, such as getting more people into affordable housing in Ward 1 and across the district, are critical elements of a comprehensive approach to addressing public safety. My vote to support this bill acknowledges the ongoing effort and conversation to recognize and effectively address the complexities inherent in DC's public safety endeavors. Thank you, Chairman.
Thank you, Councilmember Nadeau. Is there any further on the bill? Councilmember Henderson?
Thank you, Mr. Chairman, and I want to thank all of the colleagues today for their engagement on this issue. I feel as though debate and amendments are certainly important to the process and refining legislation. I think we've all heard lots of varying statements about what's happening in the city right now in terms of crime. I would say that there's not a single action or event that led to this moment, but all of us on this body have been working to address it through a variety of different approaches, whether it be funding or legislation or oversight over the agencies charged with law enforcement and public safety. I do think the improved version of the Secure DC Omnibus is part of that ongoing work. When it comes to public safety, I think we need to provide tools for not just law enforcement, but also for communities to prevent and deter crime and also hold those accountable who choose to harm others within the community. A critical piece of correcting and stopping harmful behavior is ensuring accountability. And I think that many in our communities feel as though this has been missing in our ecosystem. Whether it be consequences for speeding or for retail theft, there is a perception that there are no consequences unless you fatally harm someone. I think there's a lot in the Secure DC Omnibus. I want to highlight a couple of things that I feel like have been overlooked, like reasonable adjustments to our data sharing laws, requiring transparency for the Office of Unified Communications regarding 911 operations, which are critical, establishing grants for safety enhancing interventions in commercial corridors. And some of these changes in Secure DC, I think, also account for the changes in the ways that people have committed crimes or intimidate neighbors, such as the use of switches, which is something that you could put on a pistol and it now is comparable to an automatic weapon. Again, Secure DC is not panacea, nor is it the council's first action. And I want to be very clear on that. This is a piece of the puzzle. In the 3 years since I've been a council member, it's been the council who's established things like the hospital-based violence interruption program to intercede immediately following an incident to try to stop the cycles of retaliation. It was the council who created the Office of Neighborhood Safety and Engagement and our violence interruption programs, including taking the One's Leadership Academy down to middle school grades, recognizing things that was happening with young people. We've expanded the MPD cadet program. We've funded new cameras around the city, and this type of work will keep continuing on. I think that I say all that to say that for laws to be meaningful, investigations, charges, and trials also need to happen. So there are other parts of this ecosystem, and I encourage my colleagues in those areas of government to do their parts as well. Thank you, Mr. Chairman.
Thank you, Councilmember. Councilmember Allen.
Thank you very much, Mr. Chair. I want to start by thanking Councilmember Pinto and her team for what has been a mammoth lift, and doing so in a spirit of compromise and collaboration. I voted for this package in committee, and I'm going to do so again today. On the whole, I believe this is a strong and responsive package to the unacceptable level of violence that we've seen in our city this past year, even as I know we'll continue to work on reconciling concerns between now and second reading. Specifically, though, I'm glad to see the restoration today of many of the transparency and accountability measures that were meant to ensure public access to misconduct. Less transparency does not make us more safe. I'm glad to see everyone came to consensus on that again. I'd like to highlight a few areas within the bill where I believe we can see a direct impact on reducing violent crime once this bill takes effect. We're strengthening and clarifying carjacking laws following the Court of Appeals' earlier decision that led to several carjacking prosecutions not being able to move forward. I think that's a great example of identifying a gap in our laws and then taking action to change it. We're making shooting reviews permanent. When we talk about a whole of government approach to prevent violence rather than just react to it, it means coordination and focus. That's exactly what a shooting review does. It's a best practice in plenty of cities that have seen decreases in violent crime, and it's meant for both law enforcement and separately for the coordination of those key efforts to reach people that are at risk. As an outgrowth of this, I would love to see MPD create a non-fatal shooting unit that treats those shootings, which are just a matter of inches from being classified in a very different way, with the same seriousness that we do homicides. Adding many of the increased gun use penalties is included here. That's been included in previous criminal code revisions that were blocked by Congress. Again, it's a gap in our existing law. It was identified, and through this legislation, we're taking action. And finally, I want to thank Councilor Pinto for including my bill that expands the private security camera rebate program to now include cameras and other safety tools for our local businesses that had suffered a rash of burglaries last year. As we heard today, there may be some additional areas to keep working on between now and second reading as we get this bill across the finish line. But finally, I think that we can all feel there is a concerted effort to focus on legislation as the only answer to our public safety crisis. And this council is doing its part today to strengthen laws where needed. However, the council does not make arrests. The council does not conduct trials. The council does not hand down sentences. Council does not run or govern the federal parts of our system, from prosecution to incarceration to rehabilitation to supervision when someone comes home. We can make the necessary legislative changes to make sure our laws are on sturdy footing, but there's so much more that needs to happen for us to really drive down the unacceptable numbers of violent crime that we saw last year. The district hasn't had a gun violence prevention director since the sudden and tragic passing of Linda Harley Harper last May. The director of the Office of Neighborhood Safety Engagement has been in an interim position for well past the statutory time. When budget time comes around, this council has repeatedly had to find money to restore cuts for the critical programs that victims and survivors of violence depend on for their recovering and healing. That tells me that much more challenging work of coordination and a whole of government approach in preventing gun violence has to be prioritized more. May I have
Councilmember-
30 more seconds, Mr. Chair?
Without objection.
I also think the loss of accreditation at the Department of Forensic Sciences has gotten some attention, but I don't think it's clicked for how devastating that was. Although the agency now has accreditation to drug and biological processing as of late December, we still have backlogs of cases to analyze that will take many months to go through. There's a gap from April 2021 through today. The DFS couldn't test a substance found by MPD to confirm it was cocaine or some other prohibited substance. That means our evidence is going to private labs. It's just not being taken up and creates a bottleneck. That's likely why we saw drug prosecutions drop so sharply. And additionally, our forensic lab does not have accreditation to test firearms or perform fingerprint analyses. Overall, DC's got some of the toughest laws on the books with mandatory minimums and maxes that often outpace so-called red states. I don't say that because I don't think we have a good criminal code, because we don't. I say that because it's a simple truth, and our ancient criminal code makes us less safe and makes accountability for harm done harder to come by.
Councilmember,
Thank you, Mr. Chairman. I appreciate all the work that's gone into this today.
thank you. Councilmember Robert White.
Thank you, Chairman. I want to start by acknowledging Councilmember Pinto's efforts in introducing this bill and appreciate her dedication to addressing public safety issues. The fear in our city is real. Last Thursday evening, I came back to my office between meetings and thought I would catch up on texts. The first text I checked was from a friend who said, "Hey, I wanted to let you know the reason you haven't heard from me is because I was mugged and beaten up on Georgia Avenue, and he wanted to let me know he was recovering." The second text I checked was from an old friend who was upset that a former colleague of hers was killed in a carjacking incident in downtown. The third text I checked was from a nonprofit leader east of the river who said their office had been broken into 3 times in 10 days, and they weren't sure how long they could stay. The issues in our city are real. I heard from young people last week and then in a youth town hall the week before that they often don't participate in after-school programs after it gets dark because they're afraid of what will happen to them when they go home. So I think all of us know that not acting is not an option. But as we engage in this work, we have to make sure we are focused on fixing what's broken. That's why I introduced the Whole Government Response to Crime Act, a public safety bill that I believe gets at the root issues. If people call 911 and don't get an answer, there's no accountability and the city doesn't get safer. If police arrest somebody who's engaged in a violent crime, but they're not prosecuted, as the majority of people aren't, the city doesn't get safer. And if we don't have an accredited crime lab that can process evidence, the city doesn't get safer. We have to make sure we are focused on making the city safer in reality. We have to take an evidence-based, solutions-oriented approach. There are things in this bill that I think sound good on paper, give people the impression that it will make them safer and help them face real issues, but that in reality, it won't change the situation. For instance, open-air drug markets or drug-free zones. Open-air drug markets are real in this city, and there are seniors who tell me they're afraid to go to the store down the street because of issues happening there. But drug-free zones might shuffle the problem from one corner to the next, doesn't solve the problem. Drugs are legal right now. Possessing and selling them are an arrestable crime today. They can be prosecuted today, but they're not. So when we talk about what is going to make our city safer, we have to look at our public safety infrastructure, not just the things that sound good. This bill is a culmination of a collaborative efforts from various council members and the mayor's office. It underscores the importance of cooperation and often compromise in achieving meaningful progress, even when the result is not perfect to any of us.
Councilmember,
1 minute, Mr. Chairman.
we're going to do all these speeches at 4 minutes when we have a 3-minute clock
30 seconds, Mr. Chairman.
without objection.
A big missing piece today that I think most people recognize is prevention. I have a series of bills that I will introduce in the coming weeks aimed at prevention. But moving forward, we also have to be committed to tirelessly advocating for accountability and transparency in the implementation of this bill. I'll hold all stakeholders, including the U.S. Attorney's Office, the Metropolitan Police Department, and the executive branch, accountable for their roles in ensuring the effective execution of these provisions. These issues, prevention issues, don't get the same attention that quote unquote public safety bills get but they matter because that is the long-term effective approach to driving down crime in this city. And I hope that we will continue to focus on that as we focus on public safety in our city. Thank you, Chairman.
Thank you, Councilmember. Councilmember Fruman.
Thank you very much, Chairman Mendelson. And I too want to join in thanking Chairwoman Pinto for the extraordinary work that she's done to pull all of this together and to go through this very, very long day. Today is about accountability, and accountability is very, very important. And I think we have struck the right balance here. I think there will be more work between now and second reading, and the bill can be improved, but I very much applaud the work that you've done here. Accountability is one side of the coin here, though, because the people who are committing crimes are rational actors, and they assess what the risks are to them, and they assess what they are risking for themselves. And way too many of our residents don't have a sense of hope. And so they don't feel like they're putting that much at risk when they commit a crime. I went to YSC, the DYRS facility last week, and spoke with some of the people there, and 14, 15, 16-year-olds in for carjacking, armed robbery. And then when you ask the people who are operating the school there, what sort of level of education are these kids at when they come in, and they do an assessment, and these kids, 14, 15, 16 years old, third or fourth grade reading typically, fourth or fifth grade math typically, they don't see a future. And if we are not working very hard to ensure that everybody in this city sees a future, accountability is not going to solve our problem. Accountability is critical. And today is today, but we're coming into a budget process also. And so all of us who are supporting accountability, I think we need to take it to heart that we need to be supporting hope and opportunity when we get into that budget process, because that's a critical part of combating crime, and we need to do that too. Thank you.
Thank you, Councilmember. Councilmember Trahan White.
Thank you. I want to thank you, Councilman Pinto, and all the other members that introduced measures. I think that safety is a priority in the city. I can't go to any meeting across the city where someone is not talking about the crime in our city. The issue is that crime was okay when it was isolated to certain parts of the city or certain sections of the city. And now the entire DC, because we didn't address it, it's like cancer. If you don't treat it, it spreads, and it's spread all over the city. And I think that we have to do something. And what that something is, or somethings is what are those somethings? I don't know. Will this bill work? I don't know. But I think that doing the same thing over and over and expecting different outcomes is the definition of insanity. I do know that mass incarceration has not helped our community. It has crippled the Black community in so many different ways that we're seeing the effects of it now. So we do have to have a balance. I believe that people do need to be held accountable. You cannot just recklessly come and terrorize the community and do what you want to do and expect no consequences. But I think that we are deficient in equitable services for working class and poor people in the district. When I look at where we've been in the budget, if I look at where we've been in programming, after school programming, recreation, we are getting there, but we have missed the mark in a lot of different areas. And so we, as council members, have a role to do as the executive. But I do know that we have to continue this fight, and no one is coming to save us but us. And I know we are facing our federal partners on the Hill, but we always face them. We cannot use them as an excuse not to do our job, because we're going to be held accountable for what we've done with the votes that people put in that box to vote for us. And the prevention work has to get enhanced. I'm concerned about the one's office. Every time I turn around, I'm hearing that this program hasn't started, or this person lost their grant, or we got a new director here. We've had probably 3 directors in 4 years. And now we have an interim director now. So if we're truly concerned about public safety, we have to do prevention work as well. We have to get people access to jobs. business, but more importantly, wealth creation. Because there's direct correlation between poverty and crime. And so today is one of our many efforts to do something about this. I'm hoping with you, Councilman Pinto, and the other members, that some of the other provisions get marked up, as I alluded to earlier, some of the things that help people get their lives back after returning back to the community. Money for businesses to go and to support their businesses from the government or other partners. Money for nonprofits. Those things are critical to ensuring that we have a safe DC. I want to thank you and all of my colleagues for this measure. And I look forward to working with you in the future to figure out how we can get more things that's equitable in this bill. Thank you.
Thank you, Councilmember Parker.
I want to thank Councilmember Pinto for her work on the Secure DC legislation. And thanks to the many residents, advocates, and experts that have weighed in with the council over the last year. We have made several changes. We blocked the rollback of DC's Incarceration Reduction Amendment Act. We blocked warrantless searches of individuals on probation, which would have resurrected failed stop and frisk policies of the past. And we blocked curtailing the disclosure of body-worn camera footage in incidents involving serious uses of force. Thanks to the work of many behind the scenes up here on this dais and behind us, we have made further changes even in the last week. We eliminated most of the concerning changes to police accountability and transparency, as well as ensured that the district's vehicle pursuit and neck restraint laws continue to protect residents from dangerous police practices. I want to emphasize to anyone watching that this is in fact an iterative process, and there's still time to strengthen this bill. As I've said before, making district residents safer is going to require much more than this bill. MPD arrests per officer are 40% lower than pre-pandemic levels, and the United States Attorney pursues significantly fewer cases than they did in 2015. It is clear we need greater coordination between all of the elements of the district's full public safety apparatus. More to the point, though, our public safety conversations need to confront harder questions. Why are so many of our youth facing agencies failing basic responsibilities to link children with services? What traumas lead young men to commit violent offenses? And what violence reduction strategies do we still need to implement to reach them? How can we give district residents, including those who have become justice involved, a sense of belonging and opportunity? Ultimately, I want to make clear this point as well. We cannot and we will not tolerate the violence that has played out on the streets of the District of Columbia. While I will continue to fight to prevent more of our young people who we fail in DC classrooms every day to end up in the criminal justice system, I will also continue fighting to reduce the number of families that have to bury loved ones or who themselves have been victim of violence in the city. And we know that the safer communities are those where residents are healthier and our economy is more inclusive and key trauma reduction programs are better supported. So I too plan to vote for this legislation today and continue working with colleagues to truly and more holistically address public safety in the District of Columbia. Thank you.
Thank you, Councilmember Parker. I think that can, Councilmember Pinto.
Thank you very much, Chairman. I just want to add my thanks to so many district residents who participated in this process, to share where they disagreed, to share where we needed to make things better, stronger, different, and lend their expertise, whether it was in lived experience or subject matter expertise with something that they pursue with their work. That informed everything that we did throughout the last several months on this bill, and makes me very proud of where we ended up. I'm also very appreciative to you all of my colleagues, for your partnership and work on this. And especially thank you to you, Chairman Mendelson, for all of your collaboration and assistance in moving this body forward in what I hope is unanimous passage of Secure DC in just a moment. And I need to highlight the names of my unbelievably impressive team who worked literally every single day and night and weekend day of the last several weeks and months to get this bill right, to listen to people with opposing viewpoints, to balance many, many different interests and needs, and who care about these issues so deeply and so earnestly. And I have learned so much from you all. And so thank you so much. Our committee director, Evan Maroff, our committee staff, Stephen Palmer, Anaya Mitchell, Aloy Rodriguez Labrada, Sean Jetner, Akima Benjamin, and our personal office, who also worked hard on this in different ways, our Chief of Staff, Genevieve Hulick, Lynn Groft, Brian Romanowski, Victoria Casarubias, Maddie White, Mason Grow, and Pablo Velasco Rodriguez. This was a real team effort. Much more work is left to be done in the district to accomplish all of our goals, but I am hopeful and believe that today's action sends a very clear message that we are turning in a safer and more secure direction. It is long past due, and I thank you all for your engagement in this process and hope that you all vote yes on this bill today.
Thank you, Councilmember Pinto. Councilmember McDuffie.
Thank you, Councilmember Pinto, and to your entire team for all the work that you all have put into this. You know, I said this earlier in the breakfast, but I think it bears repeating. A lot goes into the work at the council and you know, having been in a similar position, having chaired this committee and produced comprehensive legislation, it's hard to get it to a point where, you know, you reach any degree of consensus with people in the public. But I think I having spoken to you, understand that you set about this with a real level of earnest and sincerity to get it right, and I appreciate all the work that you put into this. You know, having been here my entire life in this city and seeing some of the ups and downs that we've been on as a city over the years, it really pains me to see us back here with the level of violence that we're experiencing. But I think this bill is going to help us really address concerns that we've been seeing around some of the crime. I think my colleagues have put it well in saying that our efforts to reduce violence can't stop here. And in fact, our focus today is on accountability, as well it should be. But if you've talked to me about violence in the past, and you know that I always talk about, you know, the need to focus on both accountability and opportunity. And we got a lot more to do by way of opportunity. I do appreciate that Councilmember Pinto has worked with the executive to fund aspects of this bill. I think there's some lessons learned from me, having worked on the NEAR Act and having had a number of provisions not be funded initially and not be implemented, and therefore not really set in place some of the data-driven policies that I think was widely supported by this council unanimously and also in the public. And so I appreciate the thought you put into approaching it this way and really trying to strike that balance. There's obviously a lot more work to do. This is the stuff that keeps me up at night in the same way that it kept me up last night. You know, I'm a council member on this dais and really working to address these policies, but I gotta tell you, I leave this council when I go home and I'm a father and I'm a husband. And I really think that I just say we got a lot more work to do.
Thank you, Councilmember. I believe that's everyone who wished to speak on the bill. We have the bill before us, Madam, as amended. Madam Secretary, would you please call the roll?
Councilmember Bonds?
Yes.
Councilmember Bonds votes yes. Councilmember Fruman?
Yes.
Councilmember Fruman votes yes. Councilmember Gray?
Yes.
Councilmember Gray votes yes. Councilmember Henderson?
Yes.
Councilmember Henderson votes yes. Councilmember Louis George. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Present.
Councilmember Trayon White will be recorded as present. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Louis George.
Mr. Chairman, can we do a 2-minute?
We can, but,
I'm he- I'm
Great,
here.
she made
Been
it.
asked-
I'm here. I'm here.
She's here.
Thank you.
Councilmember Louis George.
Yes.
Councilmember Louis George votes yes. Mr. Chairman, there are 12 yeses and 1 present.
The bill on first reading is approved unanimously. Motions and requests and points of order and so forth are out of order in the midst of a vote. Just saying. We're turning to reading and vote on proposed resolutions. The first is PR 25-507, District of Columbia Sentencing Commission, Joel Caston, appointment resolution of 2024. This was approved in the committee of the whole meeting earlier this afternoon. So I'm going to say so moved, and I'm also going to ask for a roll call vote. I believe one member had asked, excuse me, a voice vote, and I believe one member had asked to be present, and that can be recorded.
Mr. Chairman,
Yes, Mr. Parker.
I move that we take a 5-minute recess.
I believe there's a feeling that there shouldn't be a recess. I
Ooh.
believe there's a feeling that there shouldn't be a recess. If you insist on a motion to recess, then I'll call a vote. Otherwise, can we keep moving? Thank you, Mr. Parker. We have Joel Caston before us. Is there discussion? By voice vote, all those in favor of the resolution say aye. Aye.
Aye.
Opposed?
Chairman, please record me as voting present.
Madam Secretary, we record Councilmember Nadeau as present. The motion is approved unanimously. We have PR 25-611, Local Rent Supplement Program Contract Number 2024 LRSP 02A with Hope View Apartments LP Approval Resolution of 2024. Councilmember Robert White.
Thank you, Chairman. This legislation would approve a subsidy for 16 apartments for extremely low-income households as part of a new construction project on Marion Berry Avenue. It comes to us from the DC Housing Authority, or DCHA, but the backstory also involves the Department of Housing and Community Development. The development team, led by T&H Investments, submitted their proposal to DHCD in response to the 2021 Consolidated Request for Proposals. They intended to build a 5-story, 42-unit affordable housing building with ground floor offices and support program space. DHCD and its partner agencies selected this proposal to receive district subsidies from various sources. Out of those subsidies, the resolution on today's agenda covers the piece that DCHA administers, project-based vouchers from the Local Rent Supplement Program, or LRSP. Once the building comes online, DCHA is committing to provide an operating subsidy to help cover rent for 16 households making 30% or less of the area median income. 12 of those 16 households will also receive permanent supportive housing services. Most of the subsidies for this project will come to us as one-time passive approval contracts. However, since LRSP is a multi-year subsidy commitment and the Home Rule Act requires affirmative approval for multi-year contracts, this one requires active vote, and active vote before the contract would automatically be disapproved on March 3rd. Based on the materials we've received, this appears to be a worthwhile project. I therefore move proposed resolution 25-611, the Local Rent Supplement Program Contract Number 2024 LRSP-02A with Hope View Apartments LR Approval Resolution of 2024. Thank you, Chairman.
Thank you. Is there discussion? Madam Secretary, is a voice vote okay? We'll have a voice vote. The vote is on PR 25-611. All those in favor say aye.
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 Are there any no votes? I don't see any no votes. The resolution is approved unanimously. Temporary legislation, Bill 25-594, Streetery Program Extension Temporary Amendment Act of 2023. Councilmember McDuffie.
Thank you, Mr. Chairman. I'd like to move to postpone the measure for consideration until March 5th for our next legislative meeting. My team and I have been in discussions both with Councilmember Allen and DDOT and APCA, and they expect to release the streetery program regulations for public comment by the time the emergency measure expires on March 20th of this year. Upon that release, I will move the temporary legislation for final reading.
The motion is to postpone to March 5th. If there's no objection, it will be postponed to March 5th. Hearing no objection, it's postponed to March 5th. Emergency legislation. The first measure is Medical Cannabis Clarification Supplemental Emergency Amendment Act of 2024. The declaration is PR 25-625. Councilmember McDuffie.
Thank you, Chairman. There exists an immediate need to provide a deadline date by which the existing facilities must file their applications with APCA for additional medical cannabis facility licenses, prohibit a cultivation center from also holding an internet retailer license, provide that the two cultivation center registration applicants that submitted an application to the Alcoholic Beverage Control Board that tied for second and received the same score be awarded a cultivation center registration, and provide that other cultivation center and dispensary registration applicants that scored 150 points or more during the same open application period be considered for a cultivation center or retailer registration. In April of last year, the council enacted legislation to address these issues. The Medical Cannabis Clarification Supplemental Temporary Amendment Act of 2023 expires on March 1st of this year. Permanent legislation addressing these issues has been introduced, but must complete the legislative process. It's vital that the provisions of the temporary act continue in effect until the permanent legislation becomes law. I move the deck.
The declaration has been moved. It's before us. Is there a discussion on the declaration? By a roll call vote, do we need a roll call vote? By roll call vote, Madam Secretary.
Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray.
Yes.
Councilmember Gray votes yes. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Lewis George is absent. Mr. Chairman, there are 12 yeses and 1 absent.
Thank you, Madam Secretary. The declaration is approved unanimously. We have the underlying bill, Bill 25-676. Councilmember McDuffie.
So move.
Discussion. Since the declaration was unanimous, we'll do a voice vote. All those in favor of the bill say aye.
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 Are there any opposed? The ayes have it unanimously. The next measure is Medical Cannabis License Clarification Emergency Amendment Act of 2024. The declaration is PR 25-626. Councilmember McDuffie on the declaration.
Thank you, Chairman. Last month, the council passed emergency legislation to clarify that ANCs within 600 feet of where medical cannabis establishment is or will be located can file a protest during the 90-day calendar, the 90 calendar day open application period, and to allow Alcoholic Beverage and Cannabis Board to extend public comment periods. With the next open application period for retailer and internet retailer social equity applicants beginning March 1st of this year, it's necessary to apply the same protest standard and extension to all cultivation center, manufacturer, retailer, and internet retailer applications. For similar consistency purposes, and concerns of overconcentration, emergency legislation is necessary to prohibit all retailer applicants from locating within 400 feet of each other. Additionally, this emergency legislation clarifies that cultivation center retailer and internet retailer licenses issued to unlicensed establishments during the statutory 90 calendar day open application period count toward the overall 50% set aside requirement for social equity applicants. Finally, emergency legislation necessary to allow APCA to issue licenses to approve unlicensed establishments by the later date of either September 30th, 2024, or within 180 days of board approval, and require unlicensed activity to cease once a license has been issued. This would stagger the demand for supply and cultivation centers and set these establishments up for success. These changes would solely assist the establishments approved for licensure, while all other unlicensed activity will remain on track for enforcement. The emergency legislation would also allow approval of establishments that choose to discontinue operations at their proposed location more time to resume operations at that location upon request. And the Committee on Business and Economic Development is currently considering the legislation to enact these changes on a permanent basis. With that, I move the deck.
Thank you, Councilmember. We have the declaration before us. Is there discussion? I have a question, Councilmember McDuffie. Reading the notice, it suggests that protests are limited to those ANC commissions within 600 feet, and the law regarding ANCs is typically an affected ANC. I'm not moving an amendment, but I'm guessing that the bill says ANCs within 600 feet and not affected ANCs.
It's effective. It's actually the same language that Councilmember Allen did last month.
That may be, that doesn't mean that. If you could maybe look at it for the temporary. I
I'm
mean,
happy to
affected
look
is
at it for the
affected,
temporary.
it's not necessarily 600 feet. If there's no other discussion on the declaration, Madam Secretary, would you call the roll?
Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes no. Gosh, Councilmember Henderson votes yes. It's been a long day. Councilmember Lewis George is absent. Councilmember McDuffie. Councilmember McDuffie.
Oh, I'm sorry. Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Mr. Chairman, there are 11 yeses and 2 absents.
If the declaration is approved unanimously, we have the underlying bill, Bill 25-678. Councilmember McDuffie.
So move.
Discussion? Since the declaration was approved unanimously, we will do a voice vote. All those in favor of the bill say aye.
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 Are there any opposed? The ayes have it unanimously. Historic preservation of derelict district properties, extension emergency declaration resolution, and the underlying emergency act. This is renewing an emergency and temporary that was adopted last year. It concerns the one remaining house, the one house out of 4 that the L'Enfant Trust is rehabilitating in the Anacostia Historic District. There has been a time limit, and this extends the time limit necessary for the trust to complete renovation and sale of the home. I move the declaration. Is there discussion?
Chairman.
Councilmember Bonds and then Councilmember White.
Thank you very much. I'm familiar with this project, and so my question is, what is the result of the sales that they do from these properties? They've done 3,
Correct.
and so what's the result?
Well, the council in its legislation, when it gave the houses to the trust, required that they had to be sold on an affordable basis. Please don't ask me what exactly level that is, because I don't know. Those 3 houses have been sold meeting that criteria.
And in the.
Fourth house is what's called Big Green, and it's
Yeah,
it was originally built as a double house.
all right. And when you say we gave them to the trust,
Yes.
it was my original understanding that they were to do the renovations and then take care of the sale. Does the resources from the sale go into the general fund?
No.
Or is this a giveaway to nonprofit?
The three houses to date have been money losers for the trust. The sale price has been less than the restoration cost.
All right, thank you.
It's really been a remarkable deal for the city, council, because, I mean, the city owned the houses. As you know, historic district standards, the owner cannot allow the house to, the structure to deteriorate, that we have a prohibition on demolition by neglect. We gave the properties to the trust. The trust is, so we have no expense here. The trust is renovating them.
All right, and so to that end, I'm just a little curious about properties that are not as deteriorated as those properties were. And how can we speed up the process of making derelict properties, bring them back into the inventory of ownership, and therefore have additional individuals, households that are into paying property taxes?
Well, my answer would be the government could be friendlier to these nonprofits that are willing to take these properties and renovate them at their expense, not ours. But as you know, because you moved the legislation 5 years ago, DHCD was extremely uncooperative.
I remember. I'm just wondering if we need to look at this program in earnest and figure out how we can make more properties available, as you say, to nonprofits, even if it means nonprofits are entity that are developed by for-profit organizations that have benefited from their relationship with the DC government, so that we can speed up this process of having more properties, livable properties throughout the
Yes.
community.
Yes, and I know your time has expired.
I know.
Councilmember Tran White.
Yes, Chairman. Do you know if the LaFont Trust did this through a community land trust?
No,
And so.
I mean, it did not.
Okay, got you. And I guess, do you know the criteria that was set for those who purchased the home? Because I hear you say affordable, but.
I do not know offhand. It was in the legislation. It required a certain level of affordability. And I believe they've worked through MANA to administer that.
Okay. I am familiar with the properties and the fourth property, and there are probably two others down there that if somebody push it, the whole house won't fall.
Correct.
And so it is our desire to create livable, equitable spaces for people in the district, especially during the housing crisis that we have. But I guess I just want to give comment to make sure it's affordable in the community, because affordability means different things to different people. You can make $150,000 and just qualify for affordability. I don't know what these particular houses were, but I'm just want to ensure that we are creating a pathway for people to get housing in the district. And I'm not sure if this is happening with our intent for this. It sounds like it is, but I just don't know the facts, just asking. So I just want to get
Yeah,
support to that.
no, this was a discussion 5 years ago. You were not on the council, and
Jim, I'm in the council 7 years.
well, then it was 8 years ago, but I remember it was LaRuby May, and LaRuby May insisted that there be an affordability provision. And so, and it met whatever, it met, as you know, we have in the law various levels of affordability, and it was consistent with one of those. And I would love for the trust to take the two that you mentioned, but my guess is the trust was so burned by this experience that they won't.
All right.
If there's no further discussion, we have the declaration before us. Madam Secretary, would you call the roll?
Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Councilmember Lewis George is absent. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trayon White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. And Councilmember Gray is absent. Mr. Chairman, there are 11 yeses and 2 absents.
I'm still dealing with how long this has been since Councilmember White notes he's been on the council for 7 years. That means it was 8 years ago that we started this. The declaration is approved unanimously. We have the underlying bill, Bill 25-688. So moved. Discussion. Since the declaration was approved unanimously, we'll do a voice vote on Bill 25-688. All those in favor say aye.
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 Are there any opposed? The ayes have it unanimously. The next measure is Street Vending Amnesty Program Facilitation Emergency Amendment Act of 2024 and the declaration, which is PR 25-628. Councilmember Nadeau.
Thank you, Chairman. I introduced this legislation to address a critical gap in the street vending amnesty program, which is a key component of the Street Vendor Advancement Amendment Act that we passed last year. Without the successful implementation of this program, many vendors will not benefit from the entirety of the legislation. I am choosing to postpone this today to give the agencies more time to work out issues that have arisen, but I remain concerned that the law may pose a fundamental barrier to the most effective implementation of the amnesty program. So I'm glad the council's attention on this issue has encouraged OCFO to work more closely on this. With that, I withdraw the amendment, the measure.
Councilmember Nadeau, so street vending amnesty is withdrawn.
Yes, sir.
All right, you're up for the next one, road barrier standardization emergency.
Yes, that one I withdrew this morning. I submitted a withdrawal of the road barrier standardization emergency. We received a commitment from the mayor that the district will store the barriers that the Adams Morgan bid purchased with OP grant funding and will work on a full transfer of ownership so that DPW can use them moving forward. That addresses the most immediate concern that was caused for emergency legislation, and I thank the mayor for working with us. I plan to introduce this as permanent legislation so we can address the issue more fully. DC stands alone in how challenging and expensive it is to temporarily close a street. And even then, the barriers used are Jersey barriers or MPD vehicles or DPW vehicles, none of which are as safe as tools actually designed for this purpose, which we now own. I think this emergency helped the executive to see where we need improvement. Members should look out for a co-introduction request from me for the permanent bill in the next week or so, but in the meantime, I withdraw this measure. Thank you, Chairman.
Thank you, Councilmember. So the measure is withdrawn. The next measure is Election Worker Protection Emergency Amendment Act of 2024. The declaration is PR 25-629. Councilmember Bonds.
Thank you, Chairman. This measure addresses safety concerns facing District of Columbia Board of Elections officials and election workers by providing additional safeguards to the workers to help ensure that the elections are safe for everyone. The hotly contested 2024 elections will bring a predictable increase in the abuse of our election officials and poll workers. It has already started. In fact, the board has received numerous threatening voicemail messages, and someone has shattered the outer glass to their office suite. The people who administer our elections are essential to the functioning of our democracy, and they deserve protection. Since the election is upon us, candidates will have begun collecting signatures and campaign signs are already popping up. Emergency legislation is therefore necessary to create criminal penalty enhancements to defer crimes against our election officials and workers as the election cycle heats up. Given that this threat, we must take action to protect our workers, given that the attacks have already begun in many of the situations including, we expect in coming months that there'll be more emphasis put on the election workers as they begin their process of administering the election. And so this emergency legislation is necessary. The emergency legislation and the ANS in particular takes into consideration that the protection would be offered during the time when the election worker is actually performing their duties. And so we wanted to make that clarifying information included in the law. And so that's what the ANS is.
So you're moving the declaration.
Yes.
Is there discussion?
Chairman Mendelson, just one quick question. I hear you that it only applies while they're doing their duties, but all around the country, we have had election officials who have been
That's right.
dogged for their election-related work outside of their workplace. And I wonder if you gave any consideration to framing it as related to their election work as opposed to simply on site, because I fear that one of the issues will be things that happen off site.
Bonds?
Councilmember Fruman, there had been some thought about that, but thinking through how we would protect a cadre of election workers going and coming to their job, doing elections work, or even in their neighborhood, it just seemed like it was cost prohibitive. So we limit it to when they're executing their assignment or their task on the premises of where the, let's say, vote count center is, or in doing those kinds of duties. And so that was why, because it might be cost prohibitive. And we wanted to move it without giving a lot of attention to what it might cost if we, to be very honest with you.
But Councilmember Bonds, I would note the language says, while the member, employer, volunteer is engaged in the performance of his or her duties or on account of the performance of those duties. So I think that's what Councilmember Fruman's talking about.
I don't know, you can, is that what you're speaking of, on account of your duties? Or are you thinking of when an individual, because they are an election official or because they are an election worker, that there might be some ramifications from doing that task that would follow them when they leave their duty station, so to speak, or the facility in which they were operating or doing their work? What were you thinking?
I'm thinking about things all around the country where actually people's lives have been ruined
That's right.
afterward, after the fact. And I thought it was an enhanced penalty as opposed to a secure. Well, I'll talk with you between the first and the second reading
Okay.
about this.
Well, it's an emergency, there would be, yeah.
Come on, guys. This is an emergency and a temporary. There'll be a second reading on the temporary.
Temporary would
When the
have a
bill
second-
was originally circulated, the bill simply said an offense against an employee of the Board of Elections. There was some concern that was not related to their duties. So language was added to
Yeah.
say while they're engaged in the performance of their duties or on account of the performance of those duties, which I think that's what you're asking about. That's the language, that's the amendment nature of a substitute. Anything further on the declaration? We'll have a roll call vote on the declaration.
Councilmember Louis George is absent. Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trayon White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray is absent. And Councilmember Henderson.
Yes.
Councilmember Henderson votes yes. Mr. Chairman, there are 11 yeses and 2 absent.
Thank you, Madam Secretary. The declaration is approved unanimously. The underlying bill, Bill 25 oh, wait a minute. Oh, yeah, no. But the underlying bill, Bill 25-684, Councilmember Bonds.
So moved.
Do you have an amendment nature of a substitute?
It is the same, it's the same amendment, so it's so moved.
Well, it's not the same. So you're moving the amendment nature of a substitute. We have the amendment in front of us. Let's try this. If there's no objection, the amendment nature of a substitute will be accepted. Hearing no objection, it's accepted. We have the bill as amended before us. Is there discussion? Since the declaration was approved unanimously, we'll do a voice vote. This is on Bill 25-684 as amended by the ANS. All those in favor say aye.
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 Opposed? The ayes have it unanimously. The next measure is Election Precinct Modernization Emergency Amendment Act of 2024. The declaration is PR 25-630. Councilmember Bonds.
This measure is withdrawn, Chairman.
Thank you. The measure is withdrawn. The next measure is DC Healthcare Alliance Enrollment Rulemaking Emergency Approval Act, and the declaration is PR 25-608. Councilmember Henderson.
Mr. Chairman, I need to withdraw this measure as all of the documents were not submitted by the executive for us to proceed.
The measure is withdrawn. The next measure is DC Healthcare Alliance Financial Eligibility Rulemaking Emergency Approval. The declaration is PR 25-607. Councilmember Henderson.
I also need to withdraw this measure because all the documents were not submitted by the executive on time.
The measure is withdrawn. All right, so we're going to turn to temporaries. No, we're not going to move them all in block. Because I believe 3 of them were never approved as emergencies. So if there's no objection, we will consider in block. Medical cannabis clarification supplemental temporary. Medical cannabis license clarification temporary. Historic preservation of derelict district properties extension temporary. Election worker protection temporary. Reflecting the amendment in the amendment of a nature of a substitute. Is that clear, Madam General Counsel?
Yes, it is.
Okay. So I'm not hearing any objection. That's 1, 2, 3, 4. 4 temporaries being moved in block. I always aggravate the secretary by saying that there'll be a
1, 2, 3, 4. 1, 2, 3, 4.
by saying there'll be a roll call.
The others were. You had one.
Hold on. There's a debate here whether it's 4 or 5. It's 4. Bill 25-677, Bill 25-679, Bill 25-689, Bill 25-685. I think that's 4.
Yep.
Took math. I took new math. Madam, the vote is on that. Hearing no discussion, Madam Secretary, call the roll. That'll get us out of here.
Councilmember McDuffie.
Yes.
Councilmember McDuffie votes yes. Chairman Mendelson.
Yes.
Chairman Mendelson votes yes. Councilmember Nadeau.
Yes.
Councilmember Nadeau votes yes. Councilmember Parker.
Yes.
Councilmember Parker votes yes. Councilmember Pinto.
Yes.
Councilmember Pinto votes yes. Councilmember Robert White.
Yes.
Councilmember Robert White votes yes. Councilmember Trahan White.
Yes.
Councilmember Trahan White votes yes. Councilmember Allen.
Yes.
Councilmember Allen votes yes. Councilmember Bonds.
Yes.
Councilmember Bonds votes yes. Councilmember Freeman.
Yes.
Councilmember Freeman votes yes. Councilmember Gray is absent. Councilmember Henderson.
Yes.
Councilmember Henderson votes yes, and Councilmember Louis George is absent. Mr. Chairman, there are 11 yeses and 2 absents.
The measures are approved first reading unanimously. That concludes the business for this meeting. The next legislative meeting is March 5th, 2024. The time is 5:31 PM, and this meeting is adjourned. Oh, you get out of here.
Mr. Chairman, do you have a tally? Megan would like to know on, Louis George's expungement, amendment. And I know you'd be writing down your little tallies, so I was trying to check.
10 to 3.